Okay, I'm trying this one more time in Facebook. I tried to do it on YouTube. Nobody was finding it over there. And then I thought about doing Zoom, but that would be too much of a pain to try and do it in this short period of time. So instead, on this one, when I set up the other ones, I was cross-posting to the Stephen Avery Project group and MAM Gossip and stuff. So I did not click to cross-post it. So is that maybe what was dragging it down and I'm not a tech person. I don't know. So please let me know, thumbs up or thumbs down, if I am freezing or whatever, if I should continue in reading this. So I have no clue on this end, because everything that I see here, it looks like it's just fine. So I don't know. Oops. Yeah, I had done the link, Tiffany, in YouTube, and then I deleted it because nobody was coming over, and then other people had problems. So I don't know. So Ashley has given me a thumbs up, and Janice says I'm good. All right, we will try starting this again. So there's a part 1 and there's a part 2. So sorry, this is being really cheesy. And so before I start, again, the thing that I'm always asked is, who am I? My name is Jax West. I run Stephen Avery Project and MAM Gossip and also Justice with Jax. I'm also with WMP Justice Review, working on other cases. Okay, thank you, Christina. And so then there is Christina and Lynn. I don't know if Lynn has found me over here. 2 of the Stephen Avery Project moderators. They will be here to answer questions, because while I'm reading to you all, I'm looking over on this screen and not looking at your comments. Janice is asking, can I do a quick recap? So far we're just going through the timeline of events. We are on page, let me do this. I've been posting the link to where you can read the brief yourself. So I'm going to start on page 28 of 150. And so this starts out at September 22, 2006. So recap. The recap was just talking about the calls in and out to Auto Trader and the timeline of when those calls came in. And then when Bobby says he saw her, and then when he left and she was gone. What is that outside my window? And it talked about stupid Kratz's press conference. Oh, sorry. Things like that. So let me continue on here. Sorry, this is all dumb. So I'm reading this brief is from October 14, 2019. We're waiting on the state's response. Jennifer is saying, I'm guessing the response is not favorable. We don't have the response yet. That is due on Friday, Jennifer. So we are just reading Kathleen Zellner's filing from October 14, 2019 as a refresher before the state's response comes in on Friday. So, and when it comes in on Friday, we'll go live, knock on wood that I don't freeze up. But I guess the key will be don't cross post any other pages, and maybe that makes it more gooder. So, all right, back into the brief. And hello, everybody who has said hello, like Patrick here in the bottom. September 22, 2006. No, Nikki, this isn't anything new. This is just what was filed as a refresher, so we know what the state is responding to. We did this, we did a live back when it came out, so there is already one, but I just decided, we're here stuck at home, so let's just read through it again. All right. So I don't know where I cut off in part 2. So I'm just starting at the top of a page that has a date. So September 22, 2006, this is page 28 of 150. The trial court ruled against the state's 9 other acts evidence, holding that it failed to find any meaningful relationship between the other acts evidence and the charged offenses. In the trial court's opinion, the other acts evidence had virtually zero probative value, would be highly prejudicial, and was clearly inadmissible. February 2, 2007. The state filed a second amended information dropping the charges for sexual assault and kidnapping. At the beginning of the trial, the state convinced the court to instruct the jury about a party to a crime theory of accomplice liability as to the homicide, mutilation of a corpse, and false imprisonment charges to be tried. Mr. Avery's blood in the RAV4 was not planted. Approximately 1 to 2 milliliters of Mr. Avery's blood, allegedly from an actively bleeding finger, was discovered in the RAV4 in 5 places, i.e. on the driver's and passenger seats, rear passenger door jamb, CD case, and by the ignition. Blood flakes were found on top of the driver's side carpet. There was no corresponding stain under the blood flakes, meaning, it didn't drip and there was blood there. How did blood flakes end up there and there's no blood underneath it? The state claimed that no one in law enforcement had access to Mr. Avery's blood prior to November 5, 2005 to plant it. The blood from Mr. Avery's bathroom was collected after the RAV4 was removed from the Avery property. Also, the state argued that trial defense counsel had failed to demonstrate exactly how the police could have planted Mr. Avery's blood in the RAV4 because of the sheer volume and the sheer number of places where the blood was discovered. Prosecutor Kratz emphasized that Mr. Avery's DNA profile from his blood in Ms. Halbach's vehicle came from the cut on the middle finger of his right hand, which occurred during his struggle with Ms. Halbach. That's a dream of his. That's not a known fact. The state's blood spatter expert, Mr. Stalkey, agreed in his testimony that the ignition stain was consistent with somebody who could be actively bleeding on their right hand. And still nobody has proven to me that if you're going to turn a key in ignition that your finger would touch the dashboard. Show me. Because that doesn't happen. In his closing, Prosecutor Kratz stated that the stain was, quote, absolutely consistent with somebody with a cut to the outside of the right hand and turning an ignition. Well, outside to the right hand would be here, but that's not where the cut was. It was the outside of his middle finger. Still, you turn a key like this. You don't turn a key like this. The state, through its expert, Dr. LeBeau, attempted to rule out the 1996 blood vial as the source of Mr. Avery's blood in the RAV4. The blood in the 1996 tube was preserved by using EDTA. Dr. LeBeau tested 3 of the 6 swabs from the RAV4 and claimed there was no EDTA in them. Ms. Halbach's blood in the RAV4. Mr. Stalkey, the state's blood spatter expert, claimed that after Ms. Halbach had been shot, which is a guess, she was thrown into the rear cargo of the RAV4, causing impact spatter on the inside of the rear cargo door. According to Mr. Stalkey, Ms. Halbach left a hair imprint from her bloodied head on the side panel of the interior of the rear cargo area. Quote, the bloody hair component, however, it is consistent with a bloody object, such as a body being comploded, phonetic, it has in quotes, or in parentheses, into the rear end of this vehicle, unquote. There was no mixture of Mr. Avery and Ms. Halbach's blood, even though Mr. Avery allegedly tossed Ms. Halbach in the RAV4 and he was, quote, actively bleeding, unquote, from his right middle finger. Despite the blood in the interior of the RAV4 being linked to Mr. Avery, there were no fingerprints of Mr. Avery on the interior or exterior of the RAV4, even though the state's fingerprint expert, Mr. Riddle, claimed that someone with sweaty hands, sweat, was more likely to leave prints than someone with dry hands. I don't know why Kratz is so infatuated with sweat. He's such a perv. Despite the blood in the interior of the RAV4 being linked to Mr. Avery, there were no fingerprints of Mr. Avery on the interior or exterior. I just read that. Prosecutor Kratz concluded that Mr. Avery touched the hood latch with his sweaty hands. Drink, sweat. That left his DNA profile. Mr. Riddle testified that he had discovered 8 latent prints on the RAV4, quote, that were suitable for comparison, unquote. One of the 8 latents contained a palm print. The latent palm prints were located where the key for the cargo gate is inserted along the pillar that goes above the tail light assembly on the other side of the wheel cover, inside a rear passenger window, and on the hood. Mr. Avery was not matched to any of the 8 latent prints. The state never claimed that Mr. Avery was wearing gloves. Mr. Riddle was never asked to examine the shell casings found in Mr. Avery's garage for fingerprints. The shell casings were never linked to the magic bullet. It doesn't say magic bullet. It says just its item number. So I'm substituting magic bullet. Her filing is professional. My reading of it, not so much. A blood stain from a male on the rear cargo door of the RAV4 did not match Mr. Avery either. But of course, they're not going to look into it because it didn't match Stephen. Page 31. No blood of Ms. Halbach in Mr. Avery's trailer, garage, or on the .22 LR Marlin Glenfield, the gun. There was no blood of Ms. Halbach in Mr. Avery's trailer, garage, or on the .22 LR Marlin Glenfield in his bedroom that was allegedly used to shoot Ms. Halbach in the head, because that's never been proven. Mr. Avery's DNA on the RAV key. Between November 5 and 9, 2005, there were 7 searches of Mr. Avery's trailer. On the 6th entry, on November 8, Ms. Halbach's Toyota key, which isn't her ignition key, was observed for the first time next to Mr. Avery's bookcase in his bedroom. The state contended that Mr. Avery kept the key so that he could move the RAV4 to crush it. During the November 8 search of Mr. Avery's bedroom, Manitowoc County Sheriff's Department Sergeant Andrew Colborn conducted an hour-long search of Mr. Avery's small bookcase. An hour. Sergeant Colborn testified that he tipped and twisted the bookcase, pulling it away from the wall. Sergeant Colborn testified that he forcefully pushed the photo album into the bookcase, causing the Toyota key to fall out the back of the shelf. Sergeant Colborn never explained how the key moved from behind the shelf to a spot on the northwest side of the bookcase by Mr. Avery's slippers, because it literally then would have hit a wall, but they're saying it hit a wall and went, yeah, okay. It's magic. During Sergeant Colborn's interaction with the bookcase, I love that wording, interaction with the bookcase, MCSD Lieutenant James Lenk left the bedroom. When Lieutenant Lenk returned, he noticed a Toyota key had suddenly appeared by the northwest side of the bookcase on the carpet. Neither side subpoenaed the bookcase for trial. The state admitted that even if the key was planted, as trial defense counsel claimed, the jury should, quote, set the key aside, unquote, because there was, quote, enough other evidence of Mr. Avery's guilt, unquote, and, quote, that key in the big picture, in the big scheme of things here, means very little, unquote. Are ya fucking kidding me right now? The state relied upon Miss Big Hair Culhane to explain the absence of Ms. Hallback's DNA on her own key by explaining that the last person to handle the key was most likely source of the DNA. Ms. Culhane testified that there was no mixture of Mr. Hallback and Mr. Avery's DNA on the key because, quote, if you have someone who's a good shedder and sheds a lot of DNA, when they touch something, a lot of studies show that it is going to be, the last person is going to be the DNA you pick up, unquote. Ms. Hallback's body burned in Mr. Avery's burn pit. The state relied upon the testimony of forensic anthropologist Dr. Eisenberg, sorry for all the eye rolls, I can't help myself, to claim that Ms. Hallback was burned in Mr. Avery's burn pit. Dr. Eisenberg testified that the primary burning episode was in the burn pit behind Mr. Avery's garage and that, quote, at least a fragment or more of almost every bone below the neck was recovered in the burn pit, unquote. Dr. Eisenberg stated on cross-examination that, quote, there is evidence from the Avery property that there was transport of human bone. And I believe that transport occurred from the original burn pit and adjacent areas to barrel number 2, unquote, which was the Dasyanda burn barrel. Okay, sorry. Dr. Eisenberg identified the bones designated by Calumet County Evidence Tag 8675 as being located southwest from the Avery property, which is called the Manitowoc County Gravel Pit. Gravel pit. So remember, Stephen never left the property, but bones at a gravel pit. Dr. Eisenberg testified that her second report was a spreadsheet of tag numbers and the evidence collected under each tag number. Dr. Eisenberg admitted that one bone fragment, 8675, from the Manitowoc County gravel pit appeared to be a human pelvic bone with, quote, a long linear cut on either side of those two bones that were still in proximity, unquote. Dr. Eisenberg, in describing the suspected human pelvic bone, stated that, quote, it was clearly a joint articulation at the right side of the pelvis where the pelvis meets the lower part of the spine, unquote. In the closing, Prosecutor Kratz stated that he would take 20 seconds to talk about the possible human pelvic bone in the Manitowoc County gravel pit. He said that these bones were possibly human, so, quote, it means that we don't know what it is, quote, unquote. Quote, Dr. Eisenberg didn't know what they were, unquote, and, quote, Dr. Fairgrieve didn't know what they were, unquote. Dr. Scott Fairgrieve was trial defense counsel's forensic anthropology expert. Some larger bones were found in the Dasyanda burn barrel, evidence tag 7964. Dr. Eisenberg described a human scapula, portions of a spinal column, metacarpals, and a fragment of long bones in the Dasyanda burn barrel. The bones found in the Dasyanda burn barrel also exhibited evidence of cut marks. Dr. Eisenberg claimed that when she opened the container of bones from the Dasyanda burn barrel, she got a, quote, waft of flammable liquid or fluid, unquote, but did not smell burned rubber from tires. Prosecutor Kratz admitted the bones were moved, but claimed, quote, the big bones, unquote, were moved by Mr. Avery from his burn pit to the Dasyanda burn barrel, quote, a couple 100 feet away, unquote. State's Attorney Thomas Sturdivant testified that the burn pit bones were, quote, intertwined or mixed, unquote, in with the steel belt from the tires. Prosecutor Kratz stated in his closing, quote, the bones being intertwined and mixed in is the state's, or one of the state's, strongest argument for this being the primary burn site, the primary. TJ's asking, what am I doing? I am reading Kathleen's filing from October. So it's just a refresher because the state is due to respond to this brief on Friday. The state claimed Wisconsin Department of Justice Division of Criminal Investigation agent Rodney Pevito ruled out the smelter and the wood burner as other possible burn sites on the Avery property. The state called DCI agent Kevin Heimerl to testify that the investigators found 5 out of the standard 6 gene rivets marked Daisy Fuentes in Mr. Avery's burn pit. The state referenced Katie Hallback's testimony that Ms. Hallback had Daisy Fuentes brand genes that were missing after her disappearance. Page 35, cause of death, 2 gunshots to head. The state claimed that Mr. Avery backed Ms. Hallback's RAV4 into his garage that was full of crap, closed the garage door, placed Ms. Hallback in the rear cargo area, then removed her from the RAV4, laid her on the garage floor, and shot her in the left side and back of her head. Makes no sense. Dr. Eisenberg testified that the defect in the parietal bone, sorry, I'm not a doctor, above the left ear showed the characteristic sign of an entrance bullet wound, and a second defect in the occipital region showed Ms. Hallback was also shot in the back of the head with a .22 caliber gun. Additionally, the state relied upon Mr. Olson, a trace metal expert, who testified that x-rays of the skull defects in the parietal region showed particles of lead. Still, there's nothing to prove that she was shot. On November 6, 2005, 11 spent shell casings were found in Mr. Avery's garage, but were never forensically linked to the magic bullet or any items of evidence in the case. The state claimed that Mr. Avery cleaned the garage, but his DNA was detected on the garage floor, as was dust. So he did a great job cleaning. Ms. Hallback's DNA on the magic bullet. There were 2 damaged bullets eventually found on Mr. Avery's garage floor on March 1 and March 2, 2006. Ms. Big Hair Culhane, the state's DNA analyst, performed DNA testing on both bullets, and DNA was only found on one. After visually examining the magic bullet and observing no signs of blood, you had to fix something, Ms. Culhane washed the bullet in a buffer solution and developed a DNA profile matching Ms. Hallback. Imagine that. Ms. Culhane was not able to determine the source of the DNA and testified that she could only determine that the DNA came from nucleated cells. Red blood cells do not have nuclei, so the DNA did not come from red blood cells. The state explained that Ms. Culhane's contamination of the control sample for the magic bullet with her own DNA during the testing process did not diminish the results of Ms. Culhane's DNA comparison and subsequent identification of Ms. Hallback's DNA. The state's ballistics expert, Mr. Newhouse, opined that the bullet containing Ms. Hallback's DNA was fired from the .22 LR Marlin Glenfield rifle mounted above Mr. Avery's bed. Mr. Newhouse's worksheet did not indicate he performed a trace examination of the magic bullet. The state's forensic pathologist, Dr. Jensen, testified that Ms. Hallback's cause of death was the result of 1 or 2 gunshot wounds to her head, which isn't proven. Specifically, Dr. Jensen testified that Ms. Hallback's DNA got on the magic bullet when it traveled through her brain, causing her death. Wrong. Dr. Eisenberg testified that there was no evidence of other gunshot wounds to the bones from other parts of Ms. Hallback's body. The state, in relying upon Dr. Jensen and Dr. Eisenberg's opinions, told the jury in its closing that Ms. Hallback was killed by gunshots to her head. No. Page 37. Mr. Avery's DNA on hood latch. The state claimed that Mr. Avery wanted to deactivate the RAV4 alarm, so he disconnected the battery cables after he opened the hood, touching the hood latch and leaving his DNA. No proof of that. Prosecutor Kratz told the jury that this DNA came from Mr. Avery's sweat. There was no witness description of Mr. Avery sweating on October 31, 2005. Ms. Culhane never mentioned sweat in her hood latch testimony. Leg irons and handcuffs were seized from Mr. Avery's bedroom. Ms. Culhane confirmed that there was no DNA of Ms. Hallback on the leg irons or the handcuffs, but there was a mixture that included Mr. Avery's DNA. Ms. Culhane agreed that this meant these items were not wiped down with bleach. So he cleaned some stuff really good, but stuff that actually touched the victim, we're not going to clean. Got it. Mr. Avery's mattress tested negative for blood, as did his knives. No hair from Miss Hallback was found in Mr. Avery's residence, including in his vacuum cleaner, which I can literally, you can't see, but I can just touch my hair and pull hair up. So, I'm sorry, no woman is going to be raped by multiple guys and dragged through a little trailer and you're not going to find her hair somewhere. Unless she's bald. On March 12, 2007, the state dismissed the false imprisonment charge. Page 38. Only one person committed the crime. Prosecutor Kratz, in his rebuttal, told the jury, quote, "It's not a difficult decision that you have to make because everything in this case pointed towards one person, towards one defendant," unquote. Yet Brendan Dassey is in prison. 2. The defense case. Mr. Avery was represented by retained attorneys Dean Strang and Jerome Buting. Mr. Avery paid trial defense counsel $220,000 for his defense. In contrast with the state's 14 expert witnesses, trial defense counsel presented 7 witnesses in total, only 2 of whom were qualified as experts. A. Defense forensic evidence. Mr. Avery's blood in the RAV4. Trial defense counsel did not have a blood spatter expert. Trial defense counsel only offered one source for the allegedly planted blood of Mr. Avery, the 1996 blood vial, which was located in an unsecured area of the courthouse. And then there's a footnote on the bottom of this page that says, in the Dassey opinion, the court references the state's theory that Brendan participated in raping and murdering Ms. Hallback with Mr. Avery, which contradicts the state's theory in Mr. Avery's trial that he was the only perpetrator. Dassey versus Dittman. In Brendan's trial, Prosecutor Kratz, so same prosecutor, claimed that Ms. Hallback was killed by Mr. Avery stabbing her in the stomach, Brendan slitting her throat, and then Mr. Avery manually strangling her. Prosecutor Kratz claimed Ms. Hallback was killed in Mr. Avery's trailer, not shot in Mr. Avery's garage. I will never understand that. Ever, 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 ever. How 2 people can be prosecuted for the same crime and totally different scenarios. How is that not reasonable doubt? How does that happen? I don't get it. Don't get it. But I'm not basically a lawyer. Obviously, this theory excluded anyone but law enforcement from planting Mr. Avery's blood. Trial defense counsel did not do their own independent testing of the 1996 blood tube. Rather, they relied upon the testimony of Janine Arvizu to try to refute Dr. LeBeau. Ms. Arvizu held a bachelor's degree in biochemistry and worked as a laboratory quality auditor. Ms. Arvizu testified that Dr. LeBeau's experiment did not account for the absence of a limit of detection. His protocol was rushed, and no one had attempted such an EDTA experiment in 10 years. Additionally, trial defense counsel presented Raleigh Johnson, the owner of Rowley. I always say Raleigh, but I think it's Rowley. the owner of Mr. Avery's trailer, who testified that he observed that the cut on Mr. Avery's finger was present prior to October 31, 2005. Discovery of RAV4 key with Mr. Avery's DNA. Trial defense counsel failed to subpoena the bookcase to demonstrate for the jury the credibility of Sergeant Colburn's description of dislodging the key from the back of the bookcase and having it migrate to the northwest side of the bookcase by Mr. Avery's slippers. Mr. Avery's trial defense counsel did not have a DNA or trace expert examine the key. So, ton of ineffective assistance of counsel all over this. Mr. Avery's DNA on hood latch. Trial defense counsel did not have a DNA expert analyze a swab from the hood latch to determine if the quantity of DNA was consistent with an individual opening a hood latch one time. Trial defense counsel did not have a trace expert analyze the hood latch swab to determine if it had actually swabbed a hood latch. Bones in Mr. Avery's burn pit. Trial defense counsel claimed the bones of Ms. Hallback were planted in Mr. Avery's burn pit, but presented no evidence as to who planted the bones, when, or how they were planted. Dr. Fairgrieve would not offer an opinion as to whether Mr. Avery's burn pit was the primary location of the body burning, and admitted that he had only looked at photographs and not examined the actual bones. Ms. Hallback's DNA on bullet. Trial defense counsel did not have a ballistics, trace, or DNA expert conduct experiments or microscopically examine the magic bullet. Trial defense counsel speculated that because Ms. Culhane had contaminated the control sample for the magic bullet, she may have also transferred Ms. Hallback's DNA onto the magic bullet. Trial defense counsel stated that Ms. Culhane had Ms. Hallback's DNA from the RAV4 cargo area, quote, sitting right there on her bench, unquote. So, quote, you can't tell how and whether Teresa Hallback's DNA ended up there in the same extraction mechanism, unquote. B. Third-party suspects. On January 30, 2007, the trial court precluded Mr. Avery from offering direct evidence, quote, that a third party other than Brendan Dassey participated in the commission of the crimes charged in the amended information. Trial counsel named third-party suspects pursuant to State v. Denny, which included Mr. Tadok, Andres Martinez, James Kennedy, Charles Avery, Mr. Fabian, Earl, Blaine, Bobby, and Brian Dassey. The trial court found that, quote, in the absence of motive, it certainly may be more difficult for the defendant to offer evidence which is relevant and material connecting a third person to the crime. The court simply finds nothing in the offer made by the defendant that goes beyond the level of speculation, unquote. The trial court did allow trial counsel in his closing to mention other suspects that were being investigated by Special Agent Thomas Fossbender and Investigator Uyghur. Trial defense counsel criticized the investigation of these suspects by pointing out that their suspicious behavior. Trial defense counsel named George Zipperer, Ms. Hallback's ex-boyfriend Ryan Hilgas, Ms. Hallback's roommate Scott Blodorn, which people don't realize Teresa Hallback was having sex with Scott Blodorn, Ms. Hallback's former married lover Bradley Check, and Ms. Hallback's business associate Thomas Pierce. Specifically, trial defense counsel pointed out Mr. Zipperer's strange behavior, the lack of alibi for Mr. Hilgas, Mr. Blodorn, and Mr. Check, and the failure for 4 days of Mr. Blodorn and Mr. Pierce to report Ms. Hallback missing. On March 18, 2007, Mr. Avery was convicted following a jury trial of first-degree intentional homicide, contrary to Wisconsin statute blah blah, and felon in possession of a firearm, contrary to Wisconsin statute blah blah. The jury found Mr. Avery not guilty of mutilation of a corpse. 3. Post-conviction and direct appeal. On August 3, 2007, Suzanne Hagopian and Martha Askins of the Wisconsin State Appellate Defender's Office were appointed as direct appeal and post-conviction counsel. On June 29, 2009, they filed a motion for post-conviction relief on Mr. Avery's behalf, pursuant to blah blah, seeking a new trial on grounds that 1. The trial court improperly excused a deliberating juror, that would be Richard Mahler, and 2. The trial court improperly excluded evidence of third-party liability. Mr. Avery's motion included a claim of ineffective assistance of counsel on the jury issue. On September 28, 2009, an evidentiary hearing was held. On October 29, 2009, a brief in support of Mr. Avery's post-conviction motion was filed. On January 25, 2010, the motion for post-conviction relief was denied by the Honorable Patrick L. Willis in a written order. There was an appeal from that decision, and that decision was affirmed by the appellate court on August 24, 2011. And in the footnote, it says, this court, in its 2011 opinion, erroneously stated that, quote, Stephen Avery was convicted as a party to the crime of the first-degree intentional homicide of Teresa Hallmark, unquote. The party to a crime language was in the second amended information, which the state had to dismiss when Brendan recanted his confession. The information upon which Mr. Avery was convicted refers to the original information and did not have the language, quote, party to a crime, unquote. Page 43. On December 14, 2011, the Wisconsin Supreme Court denied the petition for review pursuant to blah blah. 4. Pro se conviction blah blah. On February 14, 2013, Mr. Avery filed his first and only pro se collateral post-conviction motion pursuant to Wisconsin statute blah blah. The motion was denied by the Honorable, it's hard for me to say that, Judge Angela Suckowitz on November 23, 2015. Mr. Avery claimed that trial counsel failed to A. Raise the Sixth Amendment violation regarding Mr. Avery's jail conversations. It's getting dark here. I'm guessing we're going to get a storm. Sorry, squirrel. Okay, sorry. A. Raise a Sixth Amendment violation regarding Mr. Avery's jail conversations with his trial attorneys. I'm so upset that even Kratz tweeted video proving they were watching Stephen when he was talking with Buting. That's illegal. Oh, sorry. I get distracted by... Ugh. Okay. B. Suppress evidence obtained by invalid search warrants. C. Sever the felon in possession of a firearm charge. D. Develop an argument based upon available information that the state had planted evidence. E. Strike biased juror Carl Wardman. That guy infuriates me that he was on that jury and even allowed in the jury pool, but let me not fall down that rabbit hole right now. And F. Investigate relevant material issues. Mr. Avery claimed that his appellate counsel failed to argue retroactive misjoinder. Additionally, Mr. Avery claimed the trial judge was biased, and both trial and appellate counsel failed to raise the issue of the state commenting on Mr. Avery's silence in the state's closing argument. On November 23, 2015, the court denied all of the claims in Mr. Avery's motion as lacking any merit. Mr. Avery filed a notice of appeal on December 3, 2015. Now we move on to page 44 of 150. We're on section 5, motion for scientific testing, and second post-conviction. Mr. Avery obtained current post-conviction counsel in January of 2016. On August 26, 2016, current post-conviction counsel filed a motion for post-conviction scientific testing pursuant to Wisconsin statutes blah, blah, blah. On September 12, 2016, the appellate court granted current post-conviction counsel's motion to stay Mr. Avery's appeal and remanded the case to the circuit court, which entered an order on November 23, 2016, for specific items to be tested. Pursuant to that order, scientific testing was performed, and current post-conviction counsel filed a motion for post-conviction relief on June 7, 2017, and also filed a motion to dismiss Mr. Avery's pro se appeal, which was pending with the appellate court. The motion was granted on July 24, 2017. On September 18, 2017, Mr. Avery's current post-conviction counsel reached an agreement with the state to allow the June 2017 motion to be amended without opposition, to add and remove claims, and for additional scientific testing of evidence. Scheduling for a potential evidentiary hearing in the spring of 2018 was discussed because both sides, believed the circuit court would grant an evidentiary hearing on Mr. Avery's claims. On October 3, 2017, prior to the state working out the logistics of the RAV4 testing, the circuit court issued an order summarily denying Mr. Avery's June 7, 2017 motion for post-conviction relief without ordering the state to respond to Mr. Avery's motion or granting an evidentiary hearing. On October 6, 2017, current post-conviction counsel filed a motion to vacate the October 3 order, informing the court of the September 18 agreement between Mr. Avery's counsel and the state for additional scientific testing and amendment to current post-conviction counsel's motion for post-conviction relief. When the circuit court did not timely respond to current post-conviction counsel's October 6 motion to vacate, current post-conviction counsel filed a motion for reconsideration on October 23, 2017, and several supplements thereto on October 31 and November 1, 2, 16, and 17, 2017. The motion to reconsider and its supplements contained new evidence that developed after the June 7, 2017 filing and after the filing of the original motion to reconsider on October 23, 2017. On November 17, 2017, current post-conviction counsel filed a timely notice of appeal from the October 3, 2017 order. The circuit court did not rule on the October 6, 2017 motion to vacate until November 28, 2017, when it denied current post-conviction counsel's motion to vacate the October 3, 2017 order, its motion to reconsider, and its supplements. Current post-conviction counsel filed an additional timely notice of appeal on November 30, 2017, from the circuit court's order of November 28, 2017. On May 18, 2018, current post-conviction counsel submitted a motion to supplement the record on appeal with a CD disclosed for the first time by the state on April 17, 2018, which current post-conviction counsel contends contains impeaching and or exculpatory evidence. The appellate court remanded the circuit court to, quote, conduct any necessary proceedings and enter an order containing its findings and conclusions within 60 days after the supplemental post-conviction motion is filed, unquote. On September 6, 2018, after this court's deadline for decision had elapsed, the circuit court, without conducting any proceedings, denied, quote, all motions submitted by the defendant on or after July 6, 2018. Dave is talking about the cat in the background. I just caught a glimpse of that. There you go. There you go, Dave. All right. Sorry. Squirrel. Scooby, it's a cat, so I'm sorry, Scooby, but see. On January 24, 2019, current post-conviction counsel submitted a motion to the appellate court to supplement the record on appeal with an undisclosed police report dated September 20, 2011, which, according to Mr. Avery's current post-conviction counsel, reflects law enforcement's transfer of multiple human bones from the Manitowoc County gravel pit to Whiting Funeral Home for return to Teresa Halbach's family. Mr. Avery alleges that the state violated its statutory duty to preserve evidence. See Wisconsin statute, blah, blah. And the actions violated Mr. Avery's constitutional due process rights. On February 25, 2019, the appellate court granted the motion and allowed current post-conviction counsel to file a supplemental post-conviction motion. The appellate court further ordered the circuit court to, quote, conduct any proceedings necessary to address the claims raised in the supplemental post-conviction motion and to enter an order containing its findings and conclusion, unquote. On August 9, 2019, the circuit court, without conducting any proceedings, denied the motion, finding, quote, that the defendant has failed to meet his burden to establish that Wisconsin statute blah blah was violated or his constitutional rights were violated under the provisions of Youngblood versus Arizona, unquote. Mr. Avery now appeals. Page 48. Argument 1. The circuit court abused its direction in denying Mr. Avery's motion to vacate its October 3, 2017 order and allow additional scientific testing. On October 18, 2017, a meeting took place in Madison, Wisconsin, in which Kathleen Zellner and Douglas Johnson, together with prosecutors Thomas Fallon, Norman Gahn, and Mark Williams, reached an agreement regarding additional forensic testing. 1. The RAV4 would be made available to current post-conviction counsel's experts, Dr. Carl Reich and Dr. Christopher Palahniuk, for complete examination of the interior and exterior of the RAV4 for additional forensic evidence to be tested. The examination was to take place at the Calumet County Sheriff's Department, who has possession of the RAV4. In addition to gathering forensic evidence from RAV4's interior and exterior, the agreement provided for collecting swabs for testing from the following items: A, battery cables; B, bar under the driver's seat, because Teresa is short. You know, somebody would have to change that seat. Hood latch, and D, interior hood release. The prosecutors also agreed that Mr. Avery would be allowed to do the following: A, conduct more sensitive DNA testing on the license plates; B, conduct DNA testing on the lug wrench; and C, Dr. Stephen Symes and Dr. Eisenberg would conduct a microscopic examination of the pelvic bones, 8675, discovered in the Manitowoc County gravel pit to determine if they were human in origin. When current post-conviction counsel inquired as to whether the circuit court should immediately be informed of the agreement, Prosecutor Fallon stated that once he had finalized the scheduling of the RAV4 examination with the CCSD, a stipulated order could be presented to the circuit court, similar to the original stipulated order for independent scientific testing that was presented by the parties to the circuit court and entered on November 23, 2016. Prosecutors stated that they would schedule the RAV4 testing in the very near future before the weather worsened. The parties also agreed that, at that time, they would propose dates for a potential evidentiary hearing. Neither side anticipated the circuit court filing its order prior to the time Mr. Avery could notify the court of the matters set forth herein. On October 3, 2017, the Circuit Court entered an order dismissing Mr. Avery's Wisconsin statute blah blah motion for relief. On October 6, 2017, current post-conviction counsel spoke to prosecutors and informed them that Mr. Avery was filing a motion to vacate the October 3, 2017 order. Prior to filing the motion, current post-conviction counsel presented the motion to prosecutors, and prosecutors agreed to the factual accuracy of the representations regarding the content of the September 18, 2017 meeting made in the motion. The state did not file an objection to the motion. The court did not issue its ruling until November 28, 2017. The Circuit Court denied Mr. Avery's motion for relief from judgment. The parties were not required to submit proposals for further scientific testing for approval by the Circuit Court because the prior order of the trial court entered on April 4, 2007. Therefore, the Circuit Court clearly abused its discretion when it denied Mr. Avery's motion for relief from judgment. A. Standard of review. Ooh. Sorry. I get kind of squirmy. An order granting or denying relief under Wisconsin statute blah blah will not be reversed on appeal unless there has been a clear abuse of discretion. Mullen versus blah 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 blah. Under Wisconsin statute blah blah, a defendant must first file a motion with the trial court to obtain relief from a judgment or order before appealing. Otherwise, the issue will be deemed unreviewable. It is undisputed that blah blah governs civil actions. And a bunch of different cases all on here. Okay, sorry. Message. And proceedings under blah are properly considered civil in nature. Rules of practice in civil actions apply in all criminal proceedings, quote, unless the context of a rule manifestly requires a different conclusion, unquote. B. The Circuit Court erred in not complying with the prior trial court order regarding scientific testing. The original stimulated order for independent scientific testing was presented by the parties to the Circuit Court and entered by it on November 23, 2016. The order made express reference to and relied upon the trial court's April 4, 2007 order on preservation of blood evidence and independent defense testing. Quote, in order to facilitate compliance with the order on preservation of blood evidence and independent defense testing, and by the agreement of the parties, ... unquote. The trial court entered the order in 2007, contemplating future scientific developments for DNA testing. The 2007 order provides in pertinent part, quote, the state shall preserve indefinitely until further order of this court all blood stains that the state believes contain Stephen Avery's DNA and that were found in or on Teresa Halbach's vehicle in a condition suitable for further further scientific testing. The defendant, Stephen A. Avery, or any lawyer representing him may at any time submit the blood stains, swabs, and items described above to any laboratory or person the defendant may choose for independent scientific testing pursuant to Wisconsin statute blah blah blah. And now this is emphasized, without further order of this court. For purposes of illustration, not limitation, this paragraph expressly contemplates independent defense testing during any state or federal post-conviction proceedings, if any, or after any such post-conviction proceedings, unquote. As demonstrated by the trial court's April 4, 2007 order, Mr. Avery was given the authority at, quote, any time, unquote, to submit items of evidence for DNA testing. When current post-conviction counsel entered into the stipulated order in 2016 with the state, the testing items were expanded to include the RAV4 key and the magic bullet. As discussed previously, the September 18, 2017 agreement between the parties expanded the items for DNA testing even further, but is compliant with the spirit of the April 4, 2007 order, which allowed Mr. Avery to seek additional DNA testing as DNA technology improved. Any DNA evidence from a complete forensic examination of the RAV4 would be consequential to Mr. Avery's conviction because the state's case hinged on the assumption that Mr. Avery's and Ms. Hallback's biological material, to the exclusion of all others, was present in the RAV4. If biological material from another individual with no innocent explanation for having been in the RAV4 is detected therein, that exculpatory evidence would create a reasonable probability of a different outcome in satisfaction of State versus O'Brien. Because it would support the third party and frame up defenses Mr. Avery has advanced since before his 2007 trial. Exculpatory evidence detected on re-examination, quote, must be considered against the other evidence presented at trial to determine if it is reasonably probable that the movement would not have been convicted, unquote. Male DNA was detected on the RAV4 license plate. Sorry, I'm getting a million text messages right now that I'm trying to clear as they pop up on my phone. Male DNA was detected on the RAV4 license plates, but was insufficient for a profile. However, with more sensitive and advanced DNA testing developed since the trial, a full profile may be detected, which would rule out Mr. Avery as the person who removed the license plates from Ms. Hallback's vehicle. 5. Since it is undisputed that the license plates were removed from Ms. Hallback's vehicle after her murder, the detection of a full DNA profile would be consequential to Mr. Avery's conviction and would satisfy O'Brien, and if Mr. Avery is excluded from the profile, it would create a reasonable probability of a different outcome. Pursuant to Wisconsin statute blah blah, a criminal defendant may move the circuit court for post-conviction testing when the movement can show that the evidence is relevant to the investigation or prosecution. The evidence is in the possession of the government agency and that the evidence has not previously been subjected to DNA testing, or, if previously tested, may be tested using a newer technique. Wisconsin statute blah blah provides as follows, quote, if the evidence has previously been tested, it may now be subjected to another test using a scientific technique that was not available or was not utilized at the time of the previous testing, and that provides a reasonable likelihood of more accurate and probative results, unquote. The circuit court clearly abused its discretion in not vacating its October 3, 2017 order in light of the explicit language of the trial court's April 4, 2007 order. Moreover, the parties reached an agreement in reliance on the circuit court's April 4, 2007 order, which provided the parties with the authority to test forensic evidence without seeking an additional court order. Mr. Avery should be relieved of the October 3 order because he has provided sufficient reason to justify that the circuit court reached an erroneous conclusion of law by not recognizing the existence of the April 4, 2007 order. Because the conviction of Mr. Avery was primarily based on forensic evidence, further forensic testing, as agreed upon by the parties, has a reasonable likelihood of yielding exculpatory evidence that is consequential to Mr. Avery's conviction and would create a reasonable probability of a different outcome. It is noteworthy that current post-conviction counsel has paid for all the testing done to date and intended to pay for testing performed pursuant to the parties' September 18, 2017 agreement, so no financial burden is imposed upon the state. It is clear abuse of discretion for the circuit court to deprive both sides of additional testing, which will be performed at Mr. Avery's expense. 2. The circuit court abused its discretion in summarily dismissing Mr. Avery's second motion pursuant to Wisconsin statutes blah blah without addressing the 5 Brady claims raised and in subsequently denying Mr. Avery's motion to supplement, which raised a 6th Brady claim, all of which deprived him of due process in violation of the Wisconsin and United States Constitution. A. Standard of review. To establish a Brady violation, a defendant must demonstrate that 1. The prosecution suppressed evidence. Check. The evidence was favorable to the defense. Check. And 3. The evidence was material to an issue at trial. Check. Footnote says, current post-conviction counsel has expended $292,197.13 on experts as of the filing of this brief. This court reviews de novo whether the facts of a case establish a Brady violation. And now it's listing a bunch of different cases. There can be a due process violation, quote, irrespective of the good faith or bad faith of the prosecution, unquote. Quote, the prosecution's duty to disclose evidence favorable to the accused includes the duty to disclose impeachable evidence as well as exculpatory evidence, unquote. The circuit court failed to address any of Mr. Avery's 5 Brady violations filed in his motion to reconsider and its supplements, but concluded, quote, there is no argument of showing of a sufficient reason as to why these issues could not have been raised in prior motions. Without such sufficient reason, these arguments are precluded from any subsequent motion, unquote. B. Brady violation regarding Mr. Romlo. The circuit court failed to recognize that it is axiomatic that the discovery of a Brady violation subsequent to filing a motion pursuant to blah blah constitutes a sufficient reason for failing to raise the issue in a prior motion. Noting a defendant's unawareness of the legal basis of his claim may constitute a sufficient reason of satisfaction of blah blah. The defendant's unawareness of the factual basis of his claim was, quote, inextricably intertwined, unquote, with the legal basis of his claim. Pre-trial, trial defense counsel made 2 specific requests pursuant to Wisconsin statute blah blah for all exculpatory evidence and or information within the possession, knowledge, or control of the state, which would tend to negate the guilt of the defendant or which would tend to affect the weight or credibility of the evidence used against the defendant, including any inconsistent statements. A second request was made by trial defense counsel for Brady material immediately before trial on January 18, 2007. In July of 2017, a new witness, Kevin Romlo, came forward and described the most significant Brady violation in the case to that point in time. Clearly, current post-conviction counsel could not have included Mr. Romlo's affidavit in the June 7, 2017 filing since Mr. Romlo had not yet come forward with evidence that establishes a Brady violation. Mr. Romlo has provided an affidavit and supplemental affidavit to current post-conviction counsel. In these affidavits, Mr. Romlo described observing Ms. Hallback's RAV4 parked at the turnaround on State Highway 147 at the East Twin River Bridge on November 3 and 4, 2005. On November 4, Mr. Romlo disclosed his observation about seeing the vehicle during a conversation with Sergeant Colburn at the Senex station in Michigan. Immediately prior to the conversation with Sergeant Colborn, Mr. Romlow observed the missing person poster of Ms. Halbach posted on one of the doors to the Senex station and recognized the vehicle on the poster as the vehicle he had seen 2 days in a row at Highway 147 and the East Twin River Bridge. On December 12 and 19, 2016, after watching the Netflix documentary Making a Murderer more than a year after its release, Mr. Romlow, who lived in Michigan, sent text messages to Mr. Tadek telling him that he recognized Sergeant Colborn from the documentary and that Sergeant Colborn was the officer with whom he spoke on November 4, 2005 at the Senex station in Michigan. Mr. Tadek never responded to Mr. Romlow's specific request to be put in contact with Brendan's attorneys. Mr. Romlow's observation of the RAV4 on November 3 and 4, 2005 is material to the defense's theory. Woo, just got an alert, lightning strike 10 miles away. Storm a-coming. Is material to the defense theory that evidence was planted to frame Mr. Avery. If the RAV4 was spotted at the turnaround on Highway 147 on November 3 and 4, 2005, then it must have been moved and planted to the Avery property before it was discovered on November 5, 2005. Clearly, this information supports trial defense counsel's theory that the RAV4 was planted on the Avery salvage yard on November 5, 2005, and that, contrary to the state's theory, it was possible to access the Avery property and plant the vehicle. Mr. Romlow's testimony would have established that Mr. Avery was framed for Ms. Halbach's murder. A key issue in determining if the RAV4 was planted was the credibility of Sergeant Colborn. None. At trial, Sergeant Colborn testified that he was not looking at the RAV4 when he made his dispatch call regarding the vehicle's license plate number. The state argued that Sergeant Colborn made the call on November 3 to confirm the accuracy of the RAV4 license plate number previously given to him that day. Because trial defense counsel did not have a police report documenting Sergeant Colborn's conversation with Mr. Romlow, they could not impeach Sergeant Colborn regarding his denial. If trial defense counsel had been aware of the conversation between Sergeant Colborn and Mr. Romlow could have been called as a witness to impeach Sergeant Colborn. Sergeant Colborn would have been discredited, and the jury would have been provided material information proving that the RAV4 was originally at the turnaround on Highway 147 and was subsequently planted on the Avery property. The United Supreme Court in Weary v. Kane held, quote, Brady applies to evidence undermining witness credibility. Evidence qualifies as material when there is, quote, any reasonable likelihood, unquote. It could have, quote, affected the judgment of the jury, unquote. To prevail on his Brady claim, Weary need not show that he, quote, more likely than not, unquote, would have been acquitted had the new evidence been admitted, unquote. The only evidence the state presented that the RAV4 was not planted on the Avery property on October 31, 2005 was the testimony that the 15 to 20 foot high berm prevented access to the Avery property where the RAV4 was found. However, Prosecutor Kratz conceded the weakness of that argument when he admitted in his closing that the RAV4, quote, couldn't be driven into the property unless somebody knew that property, ... unquote. The only other evidence presented by the state that the RAV4 never left the Avery property after October 31, 2005 was Bobby's, the killer, testimony that the RAV4 was still present when he left the Avery property at 2:45 p.m. The footnote says the chronology of the 30 tracks of the MCSD calls to dispatch demonstrates that Sergeant Colborn's call was made on November 4, 2005. Trial defense counsel presented no evidence from witnesses that the RAV4 was planted and simply argued in the closing that there were, quote, lots of ways to get in and ... for someone to plant the vehicle, unquote. The failure of the state to disclose Mr. Romlow's interview with Sergeant Colborn is material because it would have established that the vehicle not only left the Avery property, but that it was brought back to the property and planted. If the RAV4 left the property, the state's theory that Ms. Hallback's murder occurred exclusively on the Avery property would be completely debunked. If Mr. Romlow's interview with Sergeant Colborn had been disclosed to trial defense counsel and revealed to the jury by having Mr. Romlow testify to impeach Sergeant Colborn, there is a reasonable probability that the result of the proceeding would have been different. A reasonable probability is a probability sufficient to undermine confidence in the outcome. And the footnote on this page says, current post-conviction counsel has obtained an affidavit from a second witness, Paul Burdick, on June 28, 2018, who also saw the RAV4 parked at the turnaround on 147 on October 31, 2005. Although this witness did not report this information to the police, he does corroborate Mr. and it doesn't, that's where it ends. So now we go on to page 60 of 150. C. Brady violation regarding Mr. Redant. The state committed a second Brady violation related to the RAV4 being planted when it failed to disclose information in a public report that the Department of Justice investigators provided to Joshua Redant about its belief that the RAV4 was planted on the Avery property. Mr. Redant has provided an affidavit to current post-conviction counsel that states the following, quote, at that time, around November 5, 2005, I was told by the Department of Justice agents that they believed Teresa Hallback's vehicle was driven to the Cuss Road cul-de-sac by driving west through an empty field, then south down the gravel road past the hunting camp until reaching an intersection with a gravel road that ran northeast into the Avery property. They told me that they believed Teresa Hallback's vehicle turned northeast onto that gravel road and entered the Avery property at the southwest corner. Unquote. DOJ investigators never authored a report about the information they provided to Mr. Redant. Mr. Redant's affidavit is similar to Mr. Romlow's affidavit and that it directly contradicts the state's denial that the RAV4 was planted. Furthermore, Mr. Redant's affidavit contradicts the state's representation to the jury that the Avery property was inaccessible from the Redant pit. Mr. Redant could have been called as a witness to refute the state's claim that the RAV4 was not planted and to impeach the statements about the inaccessibility of the Avery property from the Redant gravel pit. And the footnote says Romlow's claims that the RAV4 was moved from the Avery property and planted there before November 5, 2005. D. Brady violation regarding original flyover video taken on November 4, 2005. On November 4, 2005, Wendy Baldwin. Every time you read one of these names, I mean, they are all just disgusting people. And CCSD Sheriff Jerry Poggle conducted a flyover searching for the RAV4. They were in the air for around 4 hours, yet produced only 3 minutes of flyover footage. Prosecutor Kratz made a material admission when he told the jury that the RAV4 was not visible in the flyover video because he claimed the vehicle was covered with branches. Bullshit. However, the edited version did not show the southeast corner of the salvage yard at all, much less a vehicle covered with branches. Therefore, a reasonable inference from this statement to the jury is that Prosecutor Kratz saw the unedited flyover video. If the video was intentionally edited to delete the footage of the southeast corner, this is a Brady violation, because the issue of whether the RAV4 was planted was material to Mr. Avery's conviction. An evidentiary hearing is necessary to determine the credibility of the state's claim that only 3 minutes of flyover footage exists and that there were no deletions of the flyover video. E. Brady violation regarding zipper voicemail. Ms. Hallback left a voicemail on the Zipper answering machine when she could not find their residence on October 31, 2005. On November 3, when the Zippers were interviewed at 9:30 p.m., that's really late. Why would you go to somebody's house at 9:30 p.m.? Okay. They told the investigators about Ms. Hallback's message. On November 3, 2005, Ms. Hallback's voicemail was listened to by Detective Remaker of the MCSD and copied by MCSD Detective Dennis Jacobs onto a CD. The CD was never turned over to Trial Defense Counsel and has allegedly disappeared. Oh, imagine that. On April 20, 2017, Prosecutor Fallon confirmed by letter to current post-conviction counsel that neither Calumet nor the Manitowoc Sheriff's Departments have been able to locate the CD of Ms. Hallback's voicemail. The contents of the Zipper voicemail may have contradicted the timeline established by the state that Ms. Hallback's last stop was the Avery salvage yard. Suspiciously, the state never played the recording of the voicemail for the jury, but they attempted to introduce its contents through Joellen Zipper. Ms. Zipper's unimpeached testimony on the contents was that Ms. Hallback came to the Zipper property between 2 and 2:30 p.m. Corroboration of the assertion that the voicemail would have contradicted the state's timeline is found in a recorded conversation between investigator Wiegert and Detective Remaker on November 5, 2005, about the sequence of Ms. Hallback's appointments on October 31, 2005. In that conversation, which occurred after interviews with Mr. Schmitz, Mr. Avery, and Mr. Zipper, they concluded that Ms. Hallback's first appointment was with Mr. Schmitz, her second appointment was with the Averys, and her third appointment was with the Zippers. It is reasonable to infer that Investigator Wiegert and Detective Remaker based their conclusion on the Zipper's voicemail left by Ms. Hallback, which was listened to by investigators on November 3, 2005 at the Zipper's residence, recorded to a CD on November 6, 2005, and withheld from trial defense counsel. Clearly, the Zipper CD is material evidence that could have been used to impeach Ms. Zipper on the timeline and would have refuted the state's entire theory that Ms. Hallback's last step was at the Avery property. F. Brady violation regarding Ms. Heidel. Ms. Heidel has provided current post-conviction counsel with an affidavit that states that she had a telephone conversation with Ms. Hallback on October 31, 2005 at 11:35 a.m. while Ms. Hallback was driving. Ms. Hallback pulled her vehicle over to make notations on her day planner as she engaged in conversation with Ms. Heidel. There is no evidence that Ms. Hallback returned home after this conversation. According to Ms. Heidel's affidavit, she reported this conversation to law enforcement, including the fact that Ms. Hallback was driving and pulled over to check her schedule and made notations about the conversation. No report of the Heidel-Hallback conversation was ever turned over to Mr. Avery's trial defense counsel, and the state never mentioned Ms. Heidel's call to Ms. Hallback at trial. It is a reasonable inference that Ms. Hallback's day planner was in the RAV4 with her at the time of her murder. Ms. Hallback's ex-boyfriend, Mr. Hilgas, was in possession of the day planner after Ms. Hallback's murder, according to one of Ms. Hallback's friends. Items from the RAV4 have particular relevance since many things were missing that should have been present in the vehicle, such as Ms. Hallback's purse, wallet, driver's license, money, schedules, receipts, maps, Toyota master key, house key, and other items related to her activities with Auto Trader or her hustle shots. It is undisputed that items were removed from her vehicle to conceal the crime. Anyone in possession of those items would qualify as a Denny suspect because it would establish a direct link to the crime. if Ms. Heidel's report of her telephone conversation with Ms. Hallback had been disclosed to trial defense counsel by the state, it could have been used to directly connect Mr. Hilgas to the crime and firmed up Mr. Avery's theory and taken it beyond mere speculation. G. Brady violation regarding Dacianda CD. On April 17, 2018, current post-conviction counsel received the Detective Michael Velli CD for the first time from Prosecutor Fallon. The CD contained Detective Velli's forensic examination of the Dacianda computer, otherwise known as Bobby's computer. On May 18, 2018, current post-conviction counsel filed a motion to supplement the record to the appellate court with the CD. On June 11, 2018, the appellate court remanded the case to the circuit court with instructions that, quote, this appeal is remanded forthwith to the circuit court to permit Mr. Avery to pursue a supplemental post-conviction motion in connection with Avery's receipt of previously withheld discovery or other new information, unquote. The appellate court further ordered, quote, that the circuit court shall conduct any necessary proceedings and enter an order containing its findings and conclusions within 60 days after the supplemental post-conviction motion is filed, unquote. On September 6, 2018, the circuit court denied Mr. Avery's motion to supplement, holding that, quote, the defense was in full possession of the same information as the prosecution via the 7 CDs turned over pursuant to discovery, unquote. The circuit court also determined that the CDs were turned over to trial defense counsel 2 months prior to trial. Therefore, the circuit court held that Mr. Avery had failed to meet his burden of showing the evidence was suppressed. Bullshit. The Dacianda CD contained unique information not previously disclosed. Quote, the Brady obligation, another quote, does not cease to exist at the moment of conviction, but continues to apply to the motion's post-trial assertion that he did not receive a fair trial because of the concealment of exculpatory evidence known and in existence at the time of the trial, unquote. The circuit court erred when it concluded that the CD contained exactly the same information as the 7 DVDs, so nothing was suppressed. The CD contained unique information derived from Detective Velli's application of specific Hallback crime scene facts to the raw data in the 7 DVDs. The 7 DVDs did not contain the results of Detective Velli's unique search terms found exclusively on the CD. Those search results are as follows. Now remember, this is Bobby Dassey's computer. These are the things, this is the computer in Bobby's room, and these is what was searched. 2,632 search results for the terms blood, 1, body, 2,083, bondage, 3, bullet, 10, cement, 23, DNA, 3, fire, 51, gas, 50, gun, 75, handcuff, 2, journal, 106, MySpace, 61, news, 54, RAV, 74, stab, 32, throat, 2, and tires, 2. It is undisputed that the results of those unique word searches of Detective Velli were suppressed and withheld from trial defense counsel, prior post-conviction counsel, and current post-conviction counsel until April 17, 2018. Because there is no possible way prior to April 17, 2018, that current or prior counsel could have guessed the specific search terms and the results which Detective Velli obtained, Mr. Avery was deprived of this material information, which could have established a direct link between the specific evidentiary terms related to the Hallback murder and the searches performed on the Dacianda computer. The CD also contained the state's recovered pornography images relevant and material to the Hallback murder. The CD refined the 14,099 images on the 7 DVDs and recovered 1,625 violent pornography images, which had been deleted. The recovered porn depicted violent images of the torture and mutilation of young females, many of whom bore a striking resemblance to Ms. Hallback. The 1,625 images of violent pornography could have established motive for trial defense counsel's Denny motion. Failure to disclose CD prior to Denny ruling. The circuit court ignored current post-conviction counsel's argument oh my, sorry, just got a message from my tattoo guy. Okay, the circuit court ignored current post-conviction counsel's argument that trial defense counsel was completely impaired in its ability to effectively identify a motive in its Denny motion, filed on January 8, 2007, before trial. Evidence may be considered impermissibly withheld if the prosecution failed to disclose the evidence before it was too late for the defendant to make use of the evidence. The circuit court abused its discretion when it ignored Mr. Avery's argument that his Denny motion was compromised by the late disclosure of the state and chose to focus only on the disclosure of the 7 DVDs 2 months before the trial. Trial defense counsel, Mr. Buting, provided an affidavit to current post-conviction counsel explaining the effect of the late disclosure on the success of trial defense counsel's Denny motion regarding establishing the motive of Bobby. Mr. Buting states, quote, "We established that he, Bobby, had access and opportunity to have committed the crime, but the court ruled no motive was established and therefore denied the Denny motion as to Bobby Dassey and others. If there was anything that was on the CD investigator report from Detective Velli that would have linked Bobby Dassey to the violent porn images found on the Dassey computer, we would have included such information in our Denny motion. Such information could have strengthened Bobby Dassey as a possible suspect who may have sexually assaulted and killed Ms. Hallback, and specifically would have provided evidence of a motive." Unquote. Page 68. Misleading nature of the discovery or of the disclosure by Prosecutor Kratz. The state admits that the CD was suppressed from May 10, 2006 until the state disclosed it to current post-conviction counsel on April 17, 2018. Admits. Exactly 4,360 days after it was created by state's forensic examiner. The circuit court ignores Mr. Avery's argument that his defense counsel was deliberately misled by Prosecutor Kratz. In Prosecutor Kratz's December 14, 2006 letter, he did not disclose the CD, but did disclose the December 7, 2006 Thomas Fassbender report. Sorry. I try to scan these just to make sure nothing bad's going on in comments, even though I know there's people watching to make sure nothing bad's going on there. The Fassbender report was prepared 218 days after Detective Velli's final investigative report was completed for the state on May 10, 2006. Mr. Strang provided an affidavit and raised additional issues about the state's non-disclosure of the CD. On January 25, 2007, on the eve of trial, Attorney Strang received a document entitled Stipulation Project from Prosecutor Kratz. In that document, paragraph R stated, quote, "Computer analysis of Steve, Teresa's, and Brendan's computer. Mike," and it's got Velli's name spelled wrong, "on the Grand Chute PD analyzed the hard drives of these three and found nothing of evidentiary value. We may wish to introduce the fact that they looked. This stip eliminates Officer Veli, his name spelled wrong again, as a witness, unquote. Mr. Strang's affidavit states, in relevant part, quote, I accepted without challenging Ken Kratz's assertion in a January 25, 2007 email to me that Veli's analysis of, quote, Steve, Teresa's, and Brendan's, unquote, computers yielded, quote, nothing much of evidentiary value, unquote, which is ineffective assistance of counsel. With the belated production of the Veli forensic analysis to Mr. Avery's current lawyers in April 2018, and now appears to me from materials that Ms. Zellner and co-counsel have filed that the Veli forensic analysis, in fact, did include much of evidentiary value in direct contradiction to Mr. Kratz's claims. Given what I know now about the existence and content of the Veli forensic analysis, this looks to me like deceit. My firm and I did not have encased while representing Mr. Avery. I think that Mr. Buting did not either, so we could not review the data of the 7 DVDs given to us. Of course, we never got the Veli CD-ROM at all, unquote. The circuit court abused its discretion when it found that trial defense counsel had failed to exercise reasonable due diligence in the following ways. 1. Failed to request access to the NCASE program from the prosecution and, quote, was denied such access, unquote. 2. Failed to request the missing CD when they had notice of the existence of the Veli CD via Fassbender's report prior to trial. 3. Failed to submit a motion to the court requesting additional time to review this newly discovered evidence. The Wisconsin Supreme Court in State versus blah blah has specifically rejected the imposition of a reasonable diligence standard on trial defense counsel. The Wisconsin Supreme Court specifically stated, quote, this court has never analyzed a Brady claim through the lens of, quote, reasonable diligence, unquote, and we decline to adopt the requirement now due to its lack of grounding in Brady or other United States Supreme Court precedent, unquote. In Banks versus blah blah, the United States Supreme Court specifically instructed, quote, a rule thus declaring prosecutor may hide, defendant must seek, is not tenable in a system constitutionally bound to accord defendants due process, unquote. The state should not be allowed to impose a reasonable diligence standard on trial defense counsel when the state suppressed the Mr. Veli CD for 12 years. Exclusive possession and control. The Weierski court specifically overruled prior Wisconsin cases which have imposed a requirement of exclusive possession and control of the material evidence by the state. The court specifically stated, there is, quote, there is no express support in the United States Supreme Court's Brady jurisprudence for the limitation that only favorable material evidence in the, quote, exclusive possession and control, unquote, of the state must be turned over to satisfy the due process obligations enunciated in Brady. This limitation further thwarts the purpose of the state's obligation under Brady to prevent the state from withholding favorable material evidence that, quote, helps shape a trial that bears heavily on the defendant, unquote, and, quote, cast the prosecutor in the role of an architect of a proceeding that does not comport with the standards of justice, unquote. We hereby overrule the holding set forth in blah blah and its progeny that favorable material evidence is only suppressed under Brady where the withheld evidence is in the state's, quote, exclusive possession and control, unquote. Stretch. Suspiciously, the Dacianda CD was not accessible to trial defense counsel in the prosecutor files because the CD was kept in the exclusive possession of Fassbender. Even if trial defense counsel had searched the prosecutor's files, they would not have discovered the CD. Quote, the knowledge of law enforcement officers may be imputed to the prosecutor, ... The test, ... is whether by the exercise of due diligence, the prosecutor should have discovered it, unquote. Sorry, my hair's blowing in my eye. Prosecutor Kratz knew that the CD was being kept separately from the other discovery and was in the sole possession of Fassbender. The Wiersky court noted, quote, the exclusive possession and control, reasonable diligence, and intolerable burden limitations distort the original Brady analysis and the purpose behind prosecutorial obligations enunciated in Brady, unquote. Michelle just said state filed their reply brief today. Lynn, can you check on that and please let me know? The state, in its response to the motion to supplement, contended the multiple people had access to the computer, but current post-conviction counsel has provided sufficient evidence that it was only Bobby who had access to the computer during the day on weekdays. If the circuit court had conducted an evidentiary hearing, the issue of who had access to the Dassey Yanda computer during the week from 6:30 a.m. to 3:30 p.m. could have been definitively established through witness testimony. Current post-conviction counsel has asserted, based on her forensic computer expert, Gary Hunt's analysis, that the violent searches primarily occurred on weekdays when only Bobby was in residence. It is undisputed that Mr. Avery never accessed the Dassey computer, even though that's what Carla Chase likes to say. He did not have the password for the computer, nor did he possess a key to the Dassey residence, which was locked when no one was home. Not according to Carla Chase. Mr. Avery only entered the residence with the permission of a Dassey family member. Mr. Avery worked during the weekdays from 8 a.m. to 5 p.m. Mr. Avery would be eliminated from all but 15 of the 128 searches, which is 11.7%, at issue simply by having been arrested on November 9, 2005. Brendan would be eliminated from all but 26 of the 128 searches, 20.3%, at issue by having been arrested on March 1, 2006. The Wisconsin Supreme Court in Harris stated, quote, here, the undisclosed information is not directly exculpatory in the sense that DNA evidence might be because the fact that BMM had allegedly been previously sexually assaulted by her grandfather does not, in and of itself, tend to negate Harris's guilt regarding the separate assault that BMM alleged he committed. However, the evidence here constitutes impeachment information that could be used to challenge the credibility of witnesses whose credibility would have been determined. Okay, so it is filed. Can we read it? Is it available to see? Do I need to? Okay, pause for a second. All right, so Lynn posted that it has been filed. All right, so dated today, brief of respondents. Okay, hold on a second here. Sorry, I'm getting distracted now. Somebody let me know immediately if you have access to it. I'm reaching. Okay, thank you. Lynn is looking for it. I need to. If is filed. All right, so message there. Now let me do this. Sorry. Pause. Thank you, Scooby. I have just been notified that the state's response has been filed today. Let me see. Oh, it's almost 5 o'clock, damn it. So I won't be able to get it from there. All right, I'm going to go back to reading. If anybody is able to find it, that they can send it to me, please. You can send it to, you can message it to Stephen Avery Project. You can email me at it's officialstephenaveryproject@gmail.com. So, and as soon as we get our hands on it, we will go live and read it. Here on Stephen Avery Project. I don't know if we'll be able to find it where it's free or if it's something that I'll have to pay Wisconsin for, which I've had to do in the past. So, until then, I'm going to continue reading her brief. So, and thank you everybody who's looking for it. And I think tomorrow I have absolutely nothing on my schedule. Okay, thank you, Scooby. Well, sometimes, Scooby, too, that the lawyers don't even find out right away. I can tell you, like in Melissa Kaluzinski's case, the press gets the stuff before anybody else, and they've contacted Melissa's father at times to go, what's your response to this filing? And it's like, didn't even know anything had happened, and Kathleen didn't even know. So, you know, the press has their little secret people who get them the information right away. So if people can watch press may put something out before anyone else. I'm going to go back to reading. Where was I? Similar to Harris, of all of the witnesses in Mr. Avery's trial, Bobby's testimony was the most determinative of Mr. Avery's guilt because the state used it to establish that Ms. Halbach never left the Avery property. Clearly, the jury was concerned about Bobby's credibility because he was one of only 2 witnesses whose testimony the jury requested review during deliberations. Importantly, the CD timeline. Thanks, Lynn. Importantly, the CD timeline of internet searches directly contradicts Bobby's trial testimony that on October 31, he was asleep from 6:30 a.m. to 2:30 p.m. Mr. Hunt determined that the internet on the Bobby computer, I can't even call it the Dassey Yonda computer, it's Bobby's computer, was accessed on October 31, 2005, when only Bobby was home at 6:05 a.m., 6:28 a.m., 7 a.m., 9:33 a.m., 10:09 a.m., 1:08 p.m., and 1:51 p.m. This impeaches Bobby's trial testimony that he was asleep from 6:30 to 2 p.m. Oh, I thought something was happening over there, but it's a little bug crawling across my screen. On November 17, 2017, in a recent interview of Bobby by state investigators, Bobby claimed that the computer was located, quote, on a desk in the living room at the time, unquote. Liar. When Bobby was asked if the computer was ever located in his bedroom, he stated, quote, it was not, unquote. Bobby's statement is directly contradicted by the crime scene footage taken by Sergeant Tyson on November 12, 2005, which shows the computer was located in Bobby's bedroom. Bobby's statements are further contradicted by his brother Blaine, who stated in his affidavit to current post-conviction counsel on June 25, 2018, that the computer was located in Bobby's room and Bobby was the primary user of it. The suppressed impeachment evidence of the Dacianda CD is not, quote, largely cumulative of impeachment evidence petitioners already had and used at trial, nor is it simply impeachment evidence which only involved minor witnesses. As the Seventh Circuit points out in Sims versus Hyatt, the Brady materiality standard is not an admissibility test. Quote, it requires the court to gauge the potential effects on the outcome of the trial if the concealed information had been available to the defendant, unquote. Bobby was the primary witness for the state in establishing that Mr. Avery and not he was the last. Hold on. Somebody's messaging me something to another one of my pages that I don't know if it's anything on this. They're putting it to my public Jax West page. Let me jump to that and make sure it's not something on the filing. But it's going slow. Okay, wait, I'm getting this. I clicked on it and I shouldn't. It's not. It's something else. Bobby was the primary witness for the state in establishing that Mr. Avery and not he was the last person to see Ms. Hallback alive. Bobby's credibility would have been severely diminished if the jury realized that Bobby was doing the following: searching and viewing numerous images of young females who bore a striking resemblance to Ms. Hallback being tortured and sexually assaulted. Bobby was also lying to the jury about being asleep when he was doing internet searches. Bobby was searching for key terms relevant to the murder and created folders labeled Teresa Hallback and DNA, unquote. The violent pornography on the Dacianda CD fulfills the Denny motive requirement and therefore meets the materiality standard of Brady. Because the circuit court erred in its finding that the 7 DVDs and CD were identical, and therefore there was no suppression, it never reached the materiality issue of the CD's contents for Brady purposes. Wisconsin statute blah blah provides that, quote, evidence of other crimes and or wrongs and or acts when offered as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident, unquote, is admissible. The court in Dressler versus McCautry held that the acts admitted pursuant to this section were the defendant's possession of the pornographic videotapes and pictures. Those images depicting intentional violence were admitted as evidence of the defendant's motive, intent, and plan to murder the victim. The defendant in Dressler argued that the videotapes and pictures were irrelevant and constituted inadmissible propensity evidence. The Seventh Circuit disagreed, stating, quote, the fact that the defendant maintained a collection of videos and pictures depicting intentional violence is probative of the state's claim that he had an obsession with that subject. The person obsessed with violence is more likely to commit murder, and therefore the videos and photographs are relevant. The Dressler court, or unquote, the Dressler court also rejected the defendant's argument that the videos and pictures were inadmissible propensity evidence and held that, Although evidence of the general character of a defendant is inadmissible to prove he acted in conformity therewith, the above exception from blah blah was deemed to apply. Dressler is persuasive authority that the same result should occur here. Ms. Halbach was killed in a violent and vicious manner, which actually I would say we don't know that. All we know is she's gone. An obsession with images depicting sexual violence against women made it more likely that person would commit a sexual homicide. The violent sexual images were relevant to motive and would have resulted in trial defense counsel being able to establish motive to meet the Denny standard. Pause. And this is my problem, that they're going to try and say that Stephen is a pervert because they found fuzzy pink handcuffs at his trailer, but Bobby having all this stuff on his computer, oh, that's nothing. Mr. Avery's expert on sexual homicide, Ann Burgess, PhD, opines in her affidavit, relying upon 30 years of empirical research literature, there is a well-established causal connection between pornography consumption and violent behaviors. Page 76. The Brady violations, and I should post this. Hold on. Here again, because we've been on for almost 2 hours now on this one, here again is the link to where I'm reading from, in case anybody late to it wants to go and read all this for yourself, just so you have it. The Brady violations are newly discovered evidence that meet the Brady materiality standard. The decision to grant or deny a motion for a new trial based on newly discovered evidence is committed to the trial court's discretion. Quote, when moving for a new trial based on the allegation of newly discovered evidence, a defendant must prove, quote, 1, the evidence was discovered after conviction. 2, the defendant was not negligent in seeking the evidence. 3, the evidence is material to an issue in the case. And 4, the evidence is not merely cumulative, unquote. The court in State versus blah blah, quote, at the outset, we observe that the parties parse out the issues on appeal, addressing the newly discovered evidence, third-party perpetrator, Denny, evidence, and the alleged Brady violation as if disconnected. However, the overarching issue is that of newly discovered evidence under which all other issues on appeal are subsumed. We therefore... No, I can't see. We therefore examine it as such, unquote. In this case, the contents of the Veli CD qualify as new evidence because 1, the CD was first disclosed to current post-conviction counsel in 2018 after being withheld for 12 years. 2, whatever duty Mr. Avery's trial defense counsel was under to investigate the Veli CD was superseded by the prosecution's ongoing duty to disclose and not suppress evidence. 3, the evidence, i.e. recovered pornographic images and 2,632 searches for keywords related to the murder of Ms. Halbach, provided Detective Veli was material to the trial court's consideration of Denny evidence related to Bobby. 4, and the evidence, specifically the aggregated pornographic images and Detective Veli's keyword searches, was not cumulative of the 7 DVDs tendered to trial defense counsel. Rather, the evidence constitutes a unique work product that is not merely a reevaluation of existing evidence or a new appreciation of known evidence. The Veli CD was material. In order for the defendant to prevail on the third component of the Brady analysis, the suppressed evidence must be material. Quote, the evidence is material only if there is a reasonable probability that, had the evidence been disclosed to the defense, the result of the proceeding would have been different, unquote. It is not difficult to imagine what Mr. Avery's trial defense counsel could have done at trial with the knowledge of the violent pornography searches performed on the Bobby computer by Bobby, the state's primary witness. The court in Sims stated, quote, "Courts must consider the overall strength of the prosecution case, the importance of the particular witness's credibility to the prosecution case, the strength of the concealed impeachment material, and how the concealed material compares to other attacks the defense was able to make on the witness's credibility," unquote. Bobby's trial testimony was completely unrebutted by the defense. Ineffective assistance of counsel. The suppressed impeachment evidence contained in the CD was material because it was not, quote, largely cumulative of impeachment evidence petitioners had already used at trial, unquote, and because the impeachment evidence was of the state's primary witness. Mr. Avery had a constitutionally guaranteed right to present a complete defense to the charges against him. Mr. Avery was deprived of his constitutional right to present a complete defense because of the Brady violation committed by the state in failing to tender the forensic examination CD and report of Detective Velli, entitled, quote, "Dassey Computer, Final Report, Investigative Copy," unquote. The failure of trial defense counsel to have the benefit of using the CD to establish the Denny motive requirement as it pertained Bobby and or to impeach Bobby, the state's primary witness, deprived Mr. Avery of a meaningful opportunity to present a complete defense. The cumulative effect of the Brady violations establishes materiality. In addressing a Brady claim, the court is not to view each piece of suppressed evidence in isolation. Instead, the court is required to access the cumulative impact of all the suppressed evidence to determine its materiality. Suppressed evidence is material if its cumulative effect creates a reasonable probability of a different result at trial. A reasonable probability of a different result exists if the suppressed information undermines confidence in the verdict. The Kyles court noted, quote, "The question is not whether the defendant would more likely than not have received a different verdict with the evidence, but whether in its absence he received a fair trial, understood as a trial resulting in a verdict worthy of confidence," unquote. A reasonable probability is lower than a preponderance of evidence standard. It is demonstrated, heard noise downstairs. It is demonstrated where the defense shows, that the failure undermined confidence in the conviction. For example, in Bies v. Sheldon, the defendant was convicted for kidnap, assault, and murder. In addressing the cumulative impact of the undisclosed evidence, the United States Court of Appeals for the Sixth Circuit noted that the evidence had been disclosed. Had the evidence been disclosed to the defense, it would have allowed defense counsel, quote, "to construct a plausible alternative narrative of the crime," unquote. Specifically, witnesses reported seeing a group that may have included the victim taunting Cordray close in time to the victim's murder. Police had determined that Cordray's palm print was similar to the print found at the scene, and one witness noticed that Cordray had injuries to his knuckles after the murder. In vacating the defendant's conviction, the court held, quote, "These facts, had they been disclosed, would have provided a compelling counter-narrative to the state's theory of the case and could have created a reasonable doubt as to the defendant's guilt in the minds of the jurors," unquote. The undisclosed evidence to Mr. Avery would have permitted the defense to construct a plausible alternative of the crime. As stated previously, Mr. Romlow and Mr. Radon's testimony and the unedited flyover video would establish that the RAV4 was planted on the Avery property. The missing zipper voicemail and the undisclosed Heidel report would have changed the state's timeline of Ms. Halbach's activities and would have provided evidence establishing Mr. Hilligas as a Denny third-party suspect. The undisclosed Dacianda CD would have impeached Bobby, who was unimpeached as the state's primary witness, as well as established motive to name him as a Denny third-party suspect. 3. The circuit court erred as a matter of law in failing to address Mr. Avery's claim of ineffective assistance of trial counsel. A. Standard of review. The 6th and 14th Amendments of the United States Constitution guarantee Mr. Avery the right to effective assistance of counsel at critical stages of his prosecution. In order to prove that he received constitutionally inadequate assistance, Mr. Avery must show that 1. His counsel performed efficiently, and 2. Counsel's deficient performance prejudiced him. Whether Mr. Avery received ineffective assistance is a mixed question of fact and law. A circuit court's, quote, findings of fact, including the circumstances of the case and the counsel's conduct and strategy, unquote, are upheld unless clearly erroneous. Whether counsel's performance satisfies the constitutional standard for ineffective assistance of counsel is a question of law, which this court reviews de novo. B. Failure to hire experts case law. In certain cases, the duty to investigate includes a duty to consult with and call expert witnesses to testify at trial. Quote, criminal cases will arise where the only reasonable and available defense strategy requires consultation with experts or introduction of expert evidence, whether pretrial, at trial, or both, unquote. Thus, there are times where the only adequate means of challenging expert testimony elicited by the state is to introduce contrary expert testimony in favor of the defense. Finding deficient performance for the failure to consult with and call a rebuttal expert where there was significant holes in the prosecution's expert conclusions that could only be adequately addressed through contrary expert testimony. Several cases in Wisconsin, likewise, hold that the failure to investigate and or call expert witnesses to discredit the state's case and or to support the defendant's theory constitute ineffective assistance. Trial counsel rendered ineffective assistance by failing to call a pathologist to refute testimony that a cord in the defendant's van was consistent with victim's wounds. That's in a different case that they're citing. Likewise, in Thomas v. Clemens, the defendant was convicted of intentionally strangling the victim to death. The defendant's defense was that he unintentionally caused the victim's death by putting too much pressure on her neck for too long during sex. To rebut this defense, the prosecution relied on testimony from the medical examiner who performed the victim's autopsy. The medical examiner testified that the hemorrhages in the victim's eyes and abrasions to her face indicated that the pressure applied to her neck occurred during an assault and was intentional. The Seventh Circuit held that trial counsel's failure to even consider contacting a pathologist to review or challenge the medical examiner's findings constituted ineffective assistance. Specifically, counsel knew that his client claimed that the death was unintentional and that there were no signs of a struggle. The court concluded that to not even contact an expert, quote, was to accept the medical examiner's findings of intentional death without challenge and basically doom the defense's theory of the case, unquote. Page 83, C, failure to hire experts. Blood spatter. It is indisputable that the state's blood spatter expert's testimony regarding Mr. Avery's blood in the RAV4 was the most critical piece of forensic evidence used to obtain Mr. Avery's conviction. And now I'm looking at the time because holy cow, I've been on here for over 2 hours. And we've been doing this for 3 hours and I have someplace I have to be in an hour. So hopefully we get this done. The state's blood spatter expert was unrebutted because trial defense counsel failed to present a blood spatter expert on Mr. Avery's behalf. On November 16, 2017, trial defense counsel, Mr. Strang, gave current post-conviction counsel an affidavit admitting that trial defense counsel was ineffective for failing to hire a blood spatter expert. Quote, I knew that an acquittal very likely would depend in part upon an explanation for Stephen Avery's blood being found in the Toyota RAV4, other than because he was in that car himself. To my recollection, I did not consider hiring a blood spatter expert who might have done independent testing, testified, or all three as to the blood stains found in either of those two general areas of Ms. Hallback's car. I did not. Okay, that's somebody else telling me that the state responded. Hold on. Sorry. I'm trying to multitask. I did not have a strategic reason for not considering or hiring such an expert or experts, unquote. Trial defense counsel. Trial defense counsel committed themselves to one theory about the source of the planted blood by claiming that it came from the 1996 blood vial and was planted by law enforcement. However, trial defense counsel did nothing to substantiate the theory for 8 months prior to trial, and at the pretrial conference on December 20, 2006, they declined the state's offer to split the sample and perform simultaneous testing or to join the state in pursuing a single test. Mr. Avery told law enforcement that his finger, which had been cut open prior to October 31, 2005, re-bled on November 3, 2005, and dripped blood in his bathroom sink and on the bathroom floor. Mr. Avery consistently expressed his belief to his attorneys and the media that his blood found in Ms. Hallback's vehicle was planted and that it came from his trailer. In a recorded interview, he said he dripped blood from his finger into his bathroom sink. Mr. Avery's claim that he bled in his bathroom into the sink was corroborated by his blood found around his sink and on his bathroom floor. Yet he's this, mastermind cleaner, right? Cleaned all this stuff of Teresa Hallback, yet he leaves his blood in his bathroom. He told law enforcement and trial defense counsel that as he was leaving his property on November 3, 2005 and exiting onto Highway 147, he observed taillights of a vehicle close to his trailer. Mr. Avery told trial defense counsel that he noticed that the blood had been removed from his sink when he entered his bathroom early in the morning on November 4, 2005. In current post-conviction counsel's motion filed on June 7, 2017, Mr. James, a blood spatter expert, opines in his affidavit that the blood drops and flakes from Mr. Avery found in the RAV4 were not from, quote, an actively bleeding middle right finger, unquote, as the state told the jury. Prosecutor Kratz erroneously claimed that the, quote, sheer volume, the sheer number of places, unquote, rule out that the blood in the RAV4 was planted. However, only 1 to 2 milliliters of Mr. Avery's blood was found in the RAV4. You did find me, Sherry. And Sherry, yeah, we're going over Kathleen's filing from October in a refresher until we get the state's response. So we've got a couple lines out trying to find the response, but since it's now 5:24 p.m., court is closed. So we'll have to see if any press puts it out. Otherwise, we'll have to wait till tomorrow. But until then, I'm still reading the October 2019 Kathleen filing. Mr. James' experiments demonstrate that the blood was not from an actively bleeding finger because there would have been blood in many more places in the RAV4, including on the door handle, key, gear shift, interior hood release, hood latch, hood prop, or battery cable. Suspiciously, there were no bloody fingerprints of Mr. Avery in or on the RAV4, despite the fact that he could not have been wearing gloves when he allegedly deposited blood from the cut on his finger in the RAV4. Yes, Sean, you're right. Mr. James states in his affidavit that the contact stain by the ignition is consistent with being placed with an applicator. Mr. James opines that the blood flakes on the driver's side carpet rule out an actively bleeding finger because the blood would soak into the carpet and not form flakes on top of it. Similarly, EDTA blood would not form flakes on the top of the carpet. Fresh blood dripped in a sink would coagulate in approximately 15 minutes and could form some flakes that could be scooped up and planted on top of the RAV4 carpet. If Mr. Avery had bled on the carpet, there would be a corresponding stain under the blood flakes. Additionally, the remaining fresh blood could be removed and planted. In Mr. James's affidavit, he refutes the state experts, Mr. Stalky's testimony, regarding the origin of the blood spatter on the inside of the rear cargo door of the RAV4. Mr. James performed experiments which demonstrate that the blood spatter on the inside of the rear cargo door was caused by Ms. Hallback being struck with an object such as a hammer or mallet while she was laying on her back on the ground behind the vehicle after the rear cargo door was opened. Mr. James ruled out Mr. Stalky's explanation that the blood was from Ms. Hallback's hair as she was flung into the rear cargo area. The blood-stained hair pattern on the panel in the cargo area was the result of the RAV4 being driven while Ms. Hallback laid in the cargo area, bleeding from a head wound, which created multiple stains as the car moved. The blood-stained pattern evidence refutes Prosecutor Kratz's claim that the pattern was caused by the vehicle sitting stationary and Ms. Hallback being thrown in and pulled back out of the vehicle, which has never made any sense to me whatsoever on why Stephen would ever have to put her in her own vehicle. Never. Put her in, pull her out, shoot her, put her in, put her out. The blood-stained hair pattern on the panel in the cargo area. Oh, I read that part already. In a similar case in Texas, the Court of Criminal Appeals held that the failure to challenge the state's testimony concerning blood spatter constituted ineffective assistance of trial defense counsel. In Abrams, the defendant claimed that she stabbed the victim, believing him to be an intruder. Specifically, the defendant claimed that she was taking a bath when she heard noises in the other room. The state elicited testimony contrary to the defendant's version of events to the effect that blood spatter in the defendant's bathtub indicated that the tub was not wet when the blood was deposited. The court held the defense counsel's failure to challenge the state's witnesses' testimony by, for example, presenting contradictory expert testimony qualified as ineffective assistance. Mr. Audrey, it's taking her this long. Wait till her reply. Yeah. Mr. James states in his affidavit that the most likely source of Mr. Avery's planted blood was from the blood in his sink, and not blood from the 1996 blood vial as trial defense counsel claimed. Mr. James, because of his familiarity with EDTA blood vials, opines that the hole on the top of the 1996 blood vial tube was made at the time Mr. Avery's blood was put in the tube, and the blood around the stopper is a common occurrence and does not indicate that the tube was tampered with, which I've got a video proving that as well. Ballistics. Mr. Strang, in his affidavit on November 16, 2017, admitted that he was ineffective in not having ballistics and trace experts regarding the magic bullet. Trial defense counsel failed to hire a ballistic expert to rebut the state's expert's testimony that Ms. Halbach's cause of death was the result of being shot into her skull with a .22 identified as the Raleigh Johnson gun. Current post-conviction counsel's ballistic expert, Lucien Haag, states in his affidavit that the bullet had no evidence of having been shot into a skull. Mr. Haag explains that the magic bullet, identified as a .22, was comprised of such soft metal that there would be detectable bone fragments embedded in the damaged bullet if it had been fired into Ms. Halbach's skull. Mr. Haag conducted experiments that demonstrate bone would have been embedded into a .22 bullet if it was shot into bone, because no bone fragments were identified in the magic bullet. During the WSCL examination, it is Mr. Haag's opinion that the magic bullet was not fired into Ms. Halbach's skull. Trial defense counsel missed the opportunity to cross-examine Mr. Newhouse about the absence of any bone particles in his report. DNA expert, quantities of DNA on hood latch. Trial defense counsel failed to present a DNA expert at Mr. Avery's trial. Current post-conviction counsel retained DNA expert Dr. Reich, a Harvard-Stanford educated molecular biologist. Dr. Reich has offered the following opinions which refute the state's DNA evidence. 1. According to Dr. Reich, it would take approximately 90 attempts at opening the RAV4 hood latch to deposit the amount of DNA recovered by the WSCL. The WSCL identified 1.9 nanograms of DNA on the hood latch. Dr. Reich reached this conclusion by conducting a series of experiments on an identical hood latch. 2. Dr. Reich refutes the state's claim, quote, as having no scientific foundation, unquote, that the hood latch DNA was deposited by sweat from Mr. Avery's hands. This part's gross. DNA expert, groin swab. Trial defense counsel failed to investigate or raise the illegal seizure of 2 groin swabs from Mr. Avery on November 9, 2005, which could have been used to plant the DNA on the RAV4 hood latch. The facts surrounding the illegal seizure of the groin swabs are as follows. 1. Mr. Avery was arrested on a felon in possession of a gun charge on November 9, 2005, and he was taken to the Aurora Medical Center where nurse Faye Fritsch took 2 groin swabs from him in the presence of Fassbender and Wiegert. 2. After the groin swabs were taken, Fassbender and Wiegert, quote, conferred and determined that the search warrant did not call for that type of exam. Wiegert immediately stopped Nurse Fritsch and the exam was concluded, unquote. 3. According to Mr. Avery, Wiegert told Nurse Fritsch to give him the groin swabs, and Mr. Avery observed Wiegert walk to the examination room receptacle as if to discard the groin swabs, but Mr. Avery did not observe Wiegert deposit the groin swabs into the receptacle. What a perv, taking groin swabs. So gross. Mr. Avery's claim that the groin swabs were not discarded is corroborated by the following highly suspicious facts. 1. Nurse Fritsch never charted on the forensic evidence sheet that she had taken the groin swabs, even though she charted that she took buccal swabs from Mr. Avery. 2. Nurse Fritsch's charting indicates that the only law enforcement officer present was Sergeant William Tyson, but Fassbender's report indicates that he met Wiegert at the examination and both of them were present in the room. Nurse Fritsch, you're a liar. It is beyond coincidence that it was Wiegert and Fassbender who interrogated Brendan a vulnerable, intellectually impaired teenager who is most likely on the autism spectrum. They introduced the hood latch story in their March 1, 2006 interrogation. Agent Fassbender asked Brendan, quote, did he go and look at the engine? Did he raise the hood at all or anything like that to do something to that car? Unquote. On May 16, 2006, when asked how he came up with the hood latch theory, Brendan responded, quote, just guessing, unquote. It is reasonable inference that Fassbender and Wiegert were highly motivated to provide corroboration for the confession they created. Therefore, they ordered that the hood latch be swabbed for DNA evidence. On April 3, 2006, Fassbender and Wiegert specifically directed Deputy Hawkins and Sergeant Tyson to go into the storage shed where the RAV4 was located, hidden, to swab the hood latch, battery cables, and interior and exterior door handles. At 19:37 hours, Sergeant Tyson swabbed the hood latch. Deputy Hawkins took photographs, including a photograph of the swab. After Sergeant Tyson swabbed the hood latch, he gave the swab to CCSD Deputy Hawkins for storage. The instructions Fassbender and Wiegert gave Deputy Hawkins and Sergeant Tyson revealed their illegal plan because they failed to request swabbing of the interior hood release lever and hood prop, which, by necessity, Mr. Avery would have handled when opening the hood to disconnect the battery cable. They knew Mr. Avery was never in the RAV4, so no additional swabbing was requested. On April 4, 2006, Deputy Hawkins signed the hood latch swab over to Wiegert for transport to the WSCL in Madison. When Wiegert arrived at WSCL, he presented Wisconsin Department of Justice evidence transmittal form labeled blah blah. Deputy Hawkins' name was typed on the form as the submitting officer, which he was not. Then Wiegert hand-printed Deputy Hawkins' name on the form, again deliberately misidentifying Deputy Hawkins as a submitting officer, which was a complete misrepresentation. Clearly, Wiegert switched the groin and hood latch swabs and fabricated the chain of custody documentation so that it would appear that Deputy Hawkins submitted the hood latch swab to the WSCL. Trial defense counsel failed to investigate all of the surrounding circumstances that led to the groin swabs being illegally taken from Mr. Avery and the chain of custody on the submission of the alleged hood latch swab to the WSCL on April 4, 2006. According to Dr. Reich, one way for forensic evidence to be planted is by relabeling the forensic swabs. Dr. Reich offers the opinion that, quote, a rubbed groin swab taken from the defendant was relabeled and thus became evidence from a hood latch, unquote. All of this is reasonable doubt. Trial defense counsel never considered the possibility that the groin swab was substituted for the hood latch swab because they failed to investigate the chain of custody involving the hood latch and the illegal seizure of the groin swab. DNA expert Toyota key. Dr. Reich opines that the DNA found on the Toyota subkey, because you always have to make point of that, the magic key is not the key she used in her ignition. It's your valet key that nobody uses. Found in Mr. Avery's bedroom was planted. Dr. Reich conducted experiments which demonstrated that Mr. Avery deposited 10 times less DNA on the exemplar subkey than what was discovered by the WSCL and used to convict Mr. Avery. Dr. Reich states, quote, an order of magnitude difference is a significant finding, unquote. Dr. Reich's experiments refute Ms. Culhane's explanation for the presence of Mr. Avery's DNA on the key, that Mr. Avery was, quote, a good shedder, unquote. Clearly, he was not. Forensic anthropology and Kerf Marks expert. Current post-conviction counsel's forensic anthropologist with Kerf Mark expertise, Dr. Symes offered the opinion in his affidavit that a microscopic examination of the suspected human pelvic bones performed in 2005 would have determined to a high percentage of accuracy whether the pelvic bones were human. Dr. Symes also opined that it was below the standard of practice for a competent forensic anthropologist. I'm getting some weird cramping here. Anthropologists should not perform microscopic and histological examinations of the possible human pelvic bone. Neither Dr. Eisenberg nor Dr. Fairgrave performed a microscopic examination of the suspected pelvic bone. If the pelvic bones in the Manitowoc County gravel pit, which I also have to make sure you all remember that the gravel pit is not the one that is right behind touching the salvage yard, that's the quarry. There's the quarry and then gravel pit, so it's even farther away. Were shown to be human, the state's entire theory against Mr. Avery would have collapsed. The state claimed that Ms. Halbach never left the Avery property. After she arrived, was murdered in Mr. Avery's garage, and her body was burned in his burn pit. If, in fact, Ms. Halbach was murdered in the Manitowoc County gravel pit, and her body was burned there, the state could not have linked the crime exclusively to Mr. Avery. Audio enhancement expert. Current post-conviction counsel hired an audio enhancement expert to enhance the Sergeant Colburn dispatch call. I really need to go in like 20 minutes. Regarding the RAV4 license plate. The enhanced version created by the expert clearly reveals that a second person was with Sergeant Colburn that makes the statement, quote, "It's hers," unquote. The statement impeaches the testimony of Sergeant Colburn that he was not looking at the RAV4 when he made the dispatch call on his personal cell phone. Experiment to establish that RAV4 subkey was planted. Neither side subpoenaed Mr. Avery's bookcase to the trial. Trial defense counsel's failure to have the bookcase at trial to demonstrate the impossibility of the state's theory about the discovery of the key was a fatal error. A simple experiment with the bookcase and Toyota key would have conclusively demonstrated that the key was planted next to the bookcase by Sergeant Colburn and Lieutenant Lenk. Conclusive proof that this one piece of evidence was planted would have collapsed the state's house of fabricated evidence. Current post-conviction counsel had experiments performed with an identical bookcase, an identical 1999 Toyota RAV4 key, valet key, on a blue fabric lanyard that demonstrates that Sergeant Colburn's and Lieutenant Lenk's testimony about the discovery of Ms. Halbach's key in Mr. Avery's bedroom is demonstrably false. We're on page 95 of 150, but I need to go probably 610. Experiment to refute burning plastic smell of Ms. Halbach's electronic components. Current post-conviction counsel's investigator conducted a series of experiments refuting Mr. Fabian's trial testimony that on October 31, 2005, he was in the vicinity of Mr. Avery's burn barrel and smelled the distinct odor of burning plastic coming from Mr. Avery's burn barrel. Yes, Jackie, the state has responded today, but nobody has it yet. We're just going over Kathleen's filing from October. The admissibility of experiments and recreations to support and illustrate an expert's opinions is well established in Wisconsin. The Wisconsin courts have held, quote, pretrial experiments may be admitted into evidence if their probative value is not substantially outweighed by prejudice, confusion, and waste of time, ... Experts are allowed to describe such experiments, state the results, and give their conclusions based therein, unquote. the experiments conducted by Mr. Avery's experts would all be admissible according to Wisconsin case law. Ineffective assistance of trial defense counsel in obtaining experts prejudiced Mr. Avery in his defense. The circuit court failed to address any of Mr. Avery's arguments on the ineffective assistance of trial defense counsel in failing to hire experts. Mr. Avery has demonstrated that trial defense counsel's deficient performance prejudiced his defense. Mr. Avery, quote, is not required to show that counsel's deficient conduct more likely than not altered the outcome of the case, unquote. Rather, quote, the question on review is whether there is a reasonable probability that a jury viewing the evidence untainted by counsel's errors would have held a reasonable doubt respecting guilt, unquote. I will, Noel and Mahalo. Quote, reasonable probability, unquote, under this standard is defined as, quote, probability sufficient to undermine confidence in the outcome, unquote. If this test is satisfied, relief is required. No supplemental abstract inquiry into the fairness of the proceedings is permissible. In addressing this issue, the court normally must consider the totality of the circumstances and thus must assess the cumulative effects of all errors and may not merely review the effect of each in isolation. The deficiency prong of the Strickland test is met when counsel's errors were the result of oversight rather than a reasoned defense strategy. It is not necessary to demonstrate total incompetence of counsel, and Mr. Avery makes no such claim here. Rather, a single serious issue may justify reversal. Kimmelman versus Morrison, blah, 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 blah. Here, Mr. Avery's experts in blood spatter, ballistics, DNA, anthropology with Kerf Mark specialization, forensic pathology, police procedure, and audio enhancement have demonstrated that the state's experts made multiple serious errors in their unrebutted testimony to the jury. One error in and of itself justifies a reversal. Mr. Strang has provided current post-conviction counsel with affidavits admitting that it was oversight and not a reasoned defense strategy to fail to hire a blood spatter and ballistics expert. D. Failure to investigate and impeach the state's primary witness, Bobby, the killer. In determining whether counsel performed deficiently, a defendant must show that counsel's representation, quote, fell below the objective standard of reasonably effective assistance, unquote. Both failure to conduct a reasonable investigation and failure to call a witness to testify can constitute deficient performance. Incompetent investigations, which are the result of inattention or oversight, do not constitute a reasoned strategic judgment to satisfy the Constitution. Bobby was the state's primary witness against Mr. Avery. During his opening statement, Prosecutor Kratz explicitly informed the jury of the significance of Bobby's putative observations on the date of Miss Halbach's disappearance. Quote, you are going to hear that Bobby Dassey was the last person, the last citizen that will have seen Teresa Halbach alive, unquote. At trial, Bobby testified that he observed Ms. Halbach's light green or teal covered SUV pull up in his driveway at 2:30 p.m. on October 31, 2005. Bobby then observed Ms. Halbach exit her vehicle and start taking pictures of his mom's maroon van right in front of his trailer. Bobby testified that he then observed Ms. Halbach walking towards the door of Mr. Avery's trailer. The following exchange occurred between Prosecutor Kratz and Bobby the killer. Quote, question, after seeing this woman walking toward your Uncle Stephen's trailer, did you ever see this woman again? Answer, no, unquote. Bobby then testified that he took a 3 or 4 minute shower and then left his trailer to go hunting. Bobby walked to his Chevy Blazer, which was parked between the trailer and garage. Bobby testified that as he walked to his vehicle, he observed Ms. Halbach's vehicle still parked in the driveway. Was her vehicle parked in the driveway? Because the van was, do you call that the driveway? It was the road going to the driveways. Sorry. Bobby further testified that he did not see Ms. Halbach or any signs of her. Bobby testified that when he returned to his trailer around 5-ish, Ms. Halbach's vehicle was gone. During his closing argument, Prosecutor Kratz once again emphasized the importance of Bobby's testimony and vouched for his credibility. Quote, "We talked more about the timeline and we heard from Bobby Dassey, again, in the same kind of a position to be his credibility to be weighed by you, but is an eyewitness. Again, an eyewitness without any bias. It is a individual that deserves to be given a lot of credit because sometime between 2:30 and 2:45 he sees Teresa Halbach. He sees her taking photographs. He sees her finishing the photo shoot, and he sees her walking up towards Uncle Steven's trailer." Unquote. Brian, Bobby's brother, told law enforcement that Bobby saw Ms. Halbach leave the Avery property on October 31, 2005, contrary to Bobby's trial testimony. Trial defense counsel was well aware that Brian had provided law enforcement with a statement that contradicted Bobby's trial testimony that Ms. Halbach never left the property, as illustrated in their motion defendant's statement on third-party responsibility, which noted that Brian had told law enforcement that Bobby actually saw Ms. Halbach leave the Avery property. Unfortunately, trial defense counsel failed to call Brian as a witness to impeach Bobby's testimony that he never saw Ms. Halbach leave the Avery property. On October 16, 2017, Brian provided current post-conviction counsel with an affidavit confirming that Bobby told him he saw Ms. Halbach leave the Avery property on October 31, 2005. Trial defense counsel's investigator, Conrad Bates, has provided an affidavit that he was unaware of the police report of Brian's interview. In State v. Thiel, the Wisconsin Supreme Court granted post-conviction relief after the trial defense attorney failed to conduct a significant investigation. There, the defendant set forth precisely what would have been revealed had the trial defense attorney conducted an investigation consistent with the defendant's constitutional right to counsel. In the instant case, Thiel also supports Mr. Avery's position that relief is warranted because his trial defense attorneys were ineffective in failing to properly review the discovery prior to Mr. Avery's trial to fully understand Brian's statements to law enforcement. In Thiel, the defendant's allegation that his trial attorney had not reviewed all of the discovery constituted an additional basis for the Supreme Court to grant relief. The same result is compelled here. Brian was available to testify at Mr. Avery's trial and could have impeached Bobby on this critical piece of information that led to Mr. Avery's conviction. If Mr. Buting and Mr. Strang had effectively cross-examined Bobby, they could have impeached him by calling Brian. The state's most important eyewitness would have been discredited, and the state's theory that Ms. Halbach never left the property would have been refuted. Brian's testimony would have been a game changer. Applying the correct Strickland standard to the failure of trial defense counsel to impeach Bobby, it has been demonstrated to a reasonable probability that if Brian had been called as a witness to refute Bobby's statement that Ms. Halbach did not leave the Avery property, that would have been sufficient evidence to undermine the verdict. Clearly, the jury perceived that Bobby was the most important state witness in establishing Mr. Avery's guilt because the jury, during deliberations, requested to review Bobby's testimony. Wisconsin has long held that impeaching evidence may be enough to warrant a new trial. In Mr. Avery's audio-taped November 6, 2005 interview, he told the Baronet County Sheriff's Department, quote, "Well, I put the book in the house by the computer, and then I walked by my sister's and to see if Bobby was home yet, but he just left," unquote. Trial defense counsel failed to fully appreciate the police interview of Brian that would have discredited the state's primary witness, Bobby, the killer. It was Bobby, and not Mr. Avery, who was the last person to see Ms. Hallback. According to Mr. Avery's police procedure and investigation expert, Greg McCrary, Bobby should have been investigated as a potential suspect in the murder of Ms. Hallback because of his preoccupation with viewing violent pornographic images resembling Ms. Hallback, with false statements to the police, and his perjured statement at Mr. Avery's trial. Additionally, trial defense counsel could have hired a forensic pathologist, as current post-conviction counsel did, who would have offered the opinion that the scratches on Bobby's upper back that were photographed on November 9, 2005 at Aurora Medical Center were inconsistent with his statements to the police that they were caused by his 8-week puppy scratching him. Dr. Larry Blum has offered the opinion that the scratches on Bobby's upper back are inconsistent with a dog's paw and consistent with human fingernails. E. Failure to establish Mr. Hilgas as a Denny third-party suspect. Trial defense counsel failed to investigate and gather evidence about Mr. Hilgas. The following pieces of evidence regarding Mr. Hilgas were overlooked by trial defense counsel and demonstrate there was a failure to conduct a significant investigation consistent with Mr. Avery's constitutional right to have effective counsel. 1. Concealment by Mr. Hilgas of his abusive relationship with Ms. Hallback. 2. Failure to impeach Mr. Hilgas on his trial testimony that the relationship between Ms. Hallback and Mr. Blodorn was platonic, when in fact it was sexual in nature. 3. Failure to impeach Mr. Hilgas with his untruthful statement to the police about Ms. Hallback's alleged insurance claim for her damaged parking light, when in fact no such insurance claim was made, and the parking light was found in the rear cargo area of the RAV4 after Ms. Hallback's disappearance. 4. Failure to obtain an alibi from Mr. Hilgas or impeach him with the significant gaps in his phone records during the time of the murder. 5. Failure to impeach Mr. Hilgas regarding the 8 minutes and 55 seconds of telephone deletions from Ms. Hallback's phone after he obtained her username and password and accessed her phone. 6. Failure to impeach Mr. Hilgas as to his location when he received 22 unidentified dropped phone calls between 3:11 p.m. and 7:25 p.m. on November 4, 2005, the night trial defense counsel suspected the RAV4 was planted on the Avery property. 7. Failure to impeach Mr. Hilgas with the contradictory statement that the cell phone coverage on the Avery property was absolutely horrid when he had testified that he had never been on the Avery property prior to November 5, 2005. 8. Failure to discover that Mr. Hilgas was in possession of Ms. Hallback's day planner, which was in her vehicle at the time of her murder. Page 104. F. Trial defense counsel failed to investigate a variety of additional topics. Current post-conviction counsel describes in the motion for post-conviction relief, filed June 7, 2017, a variety of failures of trial defense counsel to conduct a significant investigation before trial. 4. The circuit court erred as a matter of law in ruling that it was not authorized by statute to resolve claims of ineffective assistance of prior post-conviction counsel, and that Mr. Avery would have to pursue that claim with the Court of Appeals pursuant to State v. Knight. The circuit court held that, quote, a circuit court is not authorized by statute to resolve claims of ineffective assistance of appellant counsel, State v. Knight, In this matter, if the defendant wishes to pursue the claims regarding appellate counsel, the defense may file a Knight motion with the Court of Appeals, unquote. A, standard of review. When, as here, the Circuit Court's decision turned on a matter of law, the appropriate standard of review is de novo. Whether counsel was ineffective is a mixed question of law and fact. B, Mr. Avery is not challenging ineffective of prior appellate counsel. Contrary to the Circuit Court's interpretation, Mr. Avery is not challenging the ineffective of appellate counsel. His claims focus exclusively on the deficient performance of prior post-conviction counsel and failing to raise the ineffectiveness of his trial defense counsel. Mr. Avery does not raise a single issue regarding his appellate brief or oral argument. The Wisconsin courts distinguish claims challenging the ineffectiveness of post-conviction counsel from those challenging the effectiveness of appellate counsel. Because Mr. Avery's ineffective assistance of counsel claims relate to his prior post-conviction counsel's failure to raise meritorious claims of ineffective assistance of trial rather than appellate counsel, he properly raised those issues in a blah motion with the Circuit Court. The court in Rothering stated, quote, the distinction between appellate counsel and post-conviction counsel is the decisive point here. Quote, there are two principal manifestations of appellate representation, A, the brief, and B, oral argument, unquote. Because the issues Rothering alleges appellate counsel should have briefed were waived, neither manifestation of appellate representation was deficient. What Rothering really complains of is the failure of post-conviction counsel to bring a post-conviction motion before the trial court, raising the issue of ineffective trial counsel. The allegedly deficient conduct is not what occurred before this appellate court, but rather what should have occurred before the trial court by a motion filed by post-conviction counsel. We hold that a Knight petition is not a proper vehicle for seeking redress of the alleged deficiencies of post-conviction counsel, unquote. Sorry, my nose is all itchy now. In Balliet, the defendant's post-conviction counsel raised two claims of ineffective assistance of trial counsel. Do we need to keep reading those? I'm going to skip that because I just want to see if I can get this done, and I have to decorate my car and go to wish somebody a happy birthday during, drive past the house that's going on, starts in a half hour. Mr. Avery's current claims are clearly stronger than prior post-conviction counsel's claims. Failure to hire experts. Hold on. Prior post-conviction counsel ignored the ineffectiveness of trial defense counsel failing to retain experts. Clearly, post-conviction counsel recognized the need for experts on Mr. Avery's behalf because they asked the court for an extension to retain experts and stated as follows, quote, counsel would be remiss if they did not consult with scientific experts on matters beyond their own knowledge and expertise, just as counsel would fail to satisfy their ethical obligations if they did not pursue potential leads for post-conviction relief. Unquote. All right, so we are on page 107. Let me scroll and see. Yeah, okay. I'm going to mark this down that we are on page 107. Right, that's what I said, page 107. I'm going to end this now. I'll only be gone for like an hour. It's just a drive-by, but I have to go write a happy birthday message on my car, and they literally just live across the street from me. So I'm gonna end this now, and then am I starting to peel from my sunburn? And then when it's done, I'll come back and finish this. So we are on page 107. And then we'll go live again on Stephen Avery Project. It will be labeled then part 4, since we had all the screw ups before. And I don't foresee us getting the state's response today, but we will have it tomorrow, hopefully, knock on wood, and we'll be live tomorrow as well to go over the state's response. So for now, I am out, and so it is 6:04 p.m. So figure I might be back like 7:30 ish. So think an hour and a half maybe that I'll be back. So be back in about 90 minutes. So get up, stretch your legs, go to the bathroom. I'll see you in a little while.